Yes.
Item number 52 of supplementary list. Kindly adjourn for 10 days. I have to file an affidavit matter.
The request of Mrs. A. Buzurburua, the matter stands adjourned for 4 weeks.
May I please, Your Lordship? I beg to mention for listing, Lordship, this is pension matter. Lordship, I am the mother of the. My son was serving as a teacher of a LP school. After death of my son, all the gratuity pension and benefits were taken by my wife of my son. So I am the mother of my son. It was last listed on 9/1/23. Also, kindly listed on 5.
You are claiming compassionate family pension?
Yes, Lordship.
Have you approached the authorities?
I don't know what as per my senior Lordship.
Hello. We'll have it on 19th of June.
Much obliged, Lordship.
Item 6. Item 6, Lordship. The matter become infracted.
Your name?
M.S. Alam.
M.S. Alam.
Yes.
Heard Mr. M.S. Alam, the learned counsel for the petitioner. Mr. N. Goswami appears for the government. The learned counsel appearing on behalf of the petitioner submits that the petition has become infructuous. Accordingly, the instant petition stands dismissed as it has already become infructuous.
Obliged.
Please, Your Lordship. I beg to mention item number 3. The matter I may be allowed to withdraw the petition. The matter has become infructuous. Yes, Your Lordship.
Your name?
K. Bhattacharya on behalf of P. Bora.
Get hold of somebody or wait for this matter.
I beg to mention item number 31. My lord, this matter in earlier 2 occasions it was not reached. My lord, may I say, my lord, it may be taken
30?
31.
Why?
My lord, in earlier 2 occasions, my lord, it was not reached.
Okay, we'll take it.
Thank you. May I please, Your Lordship? Your Lordship, I want to mention to this daily list 1 and 2, Your Lordship. Your Lordship, the engaged senior counsel, he comes all the way from Kolkata, Your Lordship. Suddenly, this matter was listed, Your Lordship. This matter may be listed on 29th of this month, Your Lordship.
No, not 29. Not 29. My lord.
No adjournment. Next.
I beg to mention item number 21, my lord. It is come up for under the column order no steps, my lord. The conducting counsel, Mr. D. Sonwal, she met with an accident, she is not keeping that. Otherwise, my lord will take steps, my lord, to this case. It come under the column order no steps, my lord.
A matter to be sir.
21.
After motions, we'll take,
21.
after motions, we'll take up. We'll take
21.
up. No adjournments.
Lordship.
Nothing with. If we have not taken steps, we may dismiss it or impose costs,
Lordship,
whichever may be.
I am praying on behalf of the conducting counsel.
Whoever it is, then if none appears, we'll dismiss it.
Lordship,
So you be present in the court.
Yes, your
Yes.
lordship.
And if necessary, it is more advisable that in the meantime you take your steps and come to the court. Ask whoever it is to take steps by now, by the time the matter reaches. Yes, Mr. Bora, you want to withdraw item number 3?
3 minutes. This matter became infractuous.
Mr. P. Bora, the learned senior counsel, assisted by
K. Bhattacharya.
so and so, submits that the writ petition has become infructuous and as such he may be permitted to withdraw the petition. Mr.
And for 1
N.
and 2,
Goswami appears for the government of Assam. In that view of the matter, the instant writ petition stands dismissed as it has become infructuous.
Much obliged.
Any interim orders? No.
They have an interim order, I think.
Interim orders, if any, stands vacated. Or order to leki dibo.
At number 1 and 2.
Yes. What is this matter about?
May please, your lordship. Your lordship, actually, with quoted forms, I want to state that your lordship, there was a day hearing on this stay vacating I, which we have filed, your lordship, before Honorable Justice Emma Pathak, sir. Your lordship, it was reserved for judgment, your lordship. Suddenly, it has been fixed after a 1 year gap, your lordship. I am the engaged counsel, your lordship.
Okay. What is your case about?
My lord, I am the one who had filed a writ petition, my lord. We are, they have
Who are
filed-
you?
They have filed
Lordship,
a
I am the
stay vacation.
respondent, your lordship.
Then you come here. What is all this thing? Yes, Mr.
Yes, my lord, I am the one who had filed a writ petition, my lord.
Both.
We are the,
Both the writ petitions?
yes, my lord, both the.
Yes, why have you filed it?
My lord, our grievance in 2020 was that we had given some representation before the Deputy Commissioner, JMD authority, and at that time the RERA was not functioning. And because of the COVID situation that was prevailing at that time, we filed a writ petition here for directing the RERA to take up our case and to consider our representation. Because of the COVID pandemic and the situation that was there was an exit gate in the building as per the master plan, and that was closed. So thereby the Honorable Court, after hearing us, in the motion says, directed the government authority, the DC, to look into the grievance of us, and if it is possible to open the exit gate. Accordingly, an
What exit gate?
exit gate of the compound. It is basically the first order of this Honorable Court. It was basically to direct the department to look into the grievance of the representation and come out into a consideration. So thereafter, the matter was taken up with the circle officer. The circle officer did the survey, and after the survey being done, the exit gate, which was as per the Disaster Management Act, it was opened. Thereafter, my lord, the writ petition was pending. The other two issues that was relating to was with consideration of our representations. That is the only issue. That while this writ petition was pending,
Why the two writ petitions?
because my lord, there were two residents. There were two residents, and there were two residents of the same building.
What building?
Apartment. My lord, it's an apartment.
So it is an apartment.
Yes, my lord.
The petitioners are
The petitioner are the occupants of that apartment.
apartment.
Yes.
Are you owners of the apartments?
Yes, sir, we are the owners of the apartment.
Fantastic. Now, you want the particular gate to be opened.
No, my lord, may I just take what has happened?
Yes, you take me.
Yes. My lord, at page 23 of my writ petition is my prayer, my lord.
Is your
Prayer, my lord.
page 21,
Page 20, my lord.
20?
My lord, may 2586.
Why should I take up 2586 when 2585 is there?
My lord, in the 2586, most of the pleading has been exchanged in 258.
No, I'm not concerned. First, make out your case. Then should we dismiss 2585?
No, my
As
lord.
there's no
My
case.
lord, it's a
Then
same.
come to
It's a
2585.
similar ground, my lord. So what has happened, my lord? Our prayer was that we had given representations before the respondent number 2. Respondent number 2 is, my lord, the GMDA authority. The respondent number 3 is the Deputy Commissioner Kamrup, and respondent number 4 is the Assam RERA authority.
Understood,
Yes,
Mr.
madam.
Sharma. Kindly explain this court as to why you have filed. I now understand one thing, that
Consider
you are occupants or owners of a particular apartment.
Yes, my lord.
Now, what is your grievance?
So-
Why have you given the representation?
Yeah,
I'm not concerned what.
Our representation that we gave before the DC authority was to consider our representation on 3 grounds. The first, that because there was a violation of the master plan, the GMDA should look into up. Second, before the DC authority, because of non giving up occupancy certificate, we are not able to register our sale deed. And third, ours was,
As of now, you don't have a sale deed.
as of now, our sale deed has not been registered.
So under such circumstances, you are at present in a state of agreement for sale.
Yeah, agreement for stay. So thereby being grievance by that, we preferred a representation before the authorities. The authorities slept over it, so we preferred a repetition. And
Show me the
meanwhile-
representation now. You are
Yes.
not clear on what you are saying. Show me where's the representation. Two eight eight five.
My lord, if please, my lord may just take 2586, my lord, because I have If it's a similar petition, my lord.
Then obviously we'll see from
Yes,
2585.
annexure 11, page 117. This is between, before the deputy commissioner. Request for updating the status of sale permission. 117.
Biswajit Pegu, request for
Yes.
updating the status of
The
sale permission and
related
others.
matters.
Okay, then
So this was one of our representation, my lord. And the second representation with regard to annexure 10, my lord, page 106.
to
So
whom?
this was the GMDA for Public Grievance Redressal Officer.
Breach of the deed of agreement for sale of the flats committed by Agrim Infrastructure against the buyer so and so. Now, what are you asking in this representation?
My lord, at the page,
Are you not ready?
yes, no, I'm ready, my lord. At
Then
page
tell me, why it
114,
take
my
such a
lord.
long time for you?
Yes, sir. We like to submit that RERA has made it clear the builder has to open the occupancy certificate and same is to hand it over the resident. However, in spite of paying the amount, the company has
Your
not given.
prayer
out-
is that we would
That is
like to
114.
submit that RERA had made it clear that the builder has to
To op-
obtain the occupancy
the
certificate
certificate
and the same has to be handed over to the resident.
However, in spite of our paying of the amount, the company has not given us our occupancy certificate.
So
and
that is
before
your
that-
request.
Yes, my lord, and the 14, my
Now,
lord,
who gives the occupancy
my
certificate?
DC office gives, my lord, my para.
Then why are you asking
Because my lord, without the clearance certificate from the GMDA, without the clearance certificate from the GMDA, the occupancy certificate we're never going to receive.
who gives the occupancy certificate?
The DC gives, my lord.
Is it?
So, my lord, the occupancy certificate will be given by the GMDA, my lord. NOC.
Then you
Yes,
don't know your case.
No, my lord, the GMDA will give the
The
occupancy.
GMDA gives the occupancy certificate.
my
Then,
lord, So at para 14, my lord,
but what you are asking, we would like to submit that the RERA had made it clear that the builder has to obtain the occupancy certificate. So the builder will obtain the occupancy certificate from the GMDA
yes,
and the same has to be handed over to the
the
residents.
residents.
However, in spite of the paying the amount, the company has not been given
as the
us our occupancy certificate, meaning thereby has the builder got the occupancy certificate.
No, my lord, that is where the entire when we went to the GMDA, we asked what is the status of our occupancy certificate. Because the land where the builder has built, that is a non-agricultural land. And because he's built a that we came to know later, my lord, after we filed a representation, after this matter was pending. And because of that, he is not able to pay the dues for converting the land. And that is why the GMDA has not issued the occupancy certificate to him. And there was deviation also in the master plan. And until this deviation being corrected, my lord, he cannot obtain the occupancy, he cannot obtain the clearance certificate. And
Isn't there a RERA authority?
yes, my lord.
So why you have not gone
My
there?
lord, at that time when we had filed this representation, this writ petition at 2020, RERA was not functioning.
So now it is functioning.
Yes, my lord.
Now go there.
No, our matter is already heard there. Already
No,
heard and
no,
decided.
doesn't the RERA have an appellate authority?
No, my lord, let me submit my case, my lord. Our matter is already in a way, my lord, has been decided by RERA. RERA gave a judgment in our favor.
RERA has given.
Yes.
Now, if there is a non-compliance to RERA, where do you go?
No, I have not filed. My writ petition was of 2020, and my grievance was limited to only that the High Court should direct the RERA to take up my complaint. Accordingly, by this order, the RERA took up my complaint, heard my complaint, disposed of my complaint. They participated, and it came in my favor. What they did against the interim order, the opening of the exit gate, they have filed a stay vacating, and now their entire plea is that because there was an arbitration clause in my agreement, therefore I cannot go and give representations to the departments and cannot have approach under 226. That's why they have filed a stay vacating from that order.
Those are okay. But
Yes.
what is your prayer now? Let us see. 2, 3, and 4 for consideration of the representation made by the petitioner. 2 is GMDA, 3 and 4. So the 4 has already done it.
Yes, 4 has already done it.
Now 2 and 3 is remaining.
Now, 2 and 3, if my lord, that's what our prayer was, to consider a representation. So my lord, when
To
that was a-
direct respondent number 2 to take appropriate action for compliance with the construction of so and so. So that is there. To direct respondent to grant the sale permission to the petitioner so that the sale deed can be registered. To direct the respondent number 4 for taking cognizance of the complaint against so and so. 4, have they not taken?
my lord, they have taken, my lord.
Then why are you approaching this court?
My lord, at the time, I'm again submitting it, my lord. When
I understand. You
Yes.
say that you are submitting that because at that time the COVID was going, the RERA was not functioning.
Yes,
Therefore, it is there.
Yes.
So you have no prayer as regards 2, 3, as regards 4.
yes, my lord.
Now you are only as regards 2 and
That's
3.
3, yes, my lord. That's my
Okay.
only prayer.
Now 2 and 3, how can this court direct the respondent
To
number
consider my
3 to grant the sale permission?
No, only to consider my representation, my lord. That is my only prayer.
And as regards 2,
With regard to take to appropriate action, my lord, even the GMD, even the RERA, because now this issue is under RERA, RERA also have directed the GMDA to look into it.
so then
Even the
that
GMDA
where is you will
Yes.
take up the action with before
And in
RERA.
fact, my lord, the GMD has filed an affidavit. They have filed an affidavit.
In
and
which case?
In both the cases, my lord.
Yes, GMDA, who is appearing? Just tell me what is your case. Necessary matters of. Where's your affidavit? Occupancy certificate with reference to so and so. I would like to inform you that your proposal cannot be considered for approval due to deviation from the demand. Earlier, the building permission for the apartment building so and so, with 1 exit and 1 exit as per the approved plan. However, after verification, it is seen that the provision of an exit is blocked from your end in violation of the approved plan. In addition to the violation of a. Okay. Minutes of the meeting of the office chamber, circle officer.
My lord, the affidavit is opposition.
Demolition of the blockade.
29/11,
is part
2021.
of plan 50. In addition to, there is no reason why the residents should suffer for the proposed commercial building of the Vinaya Atara and after hearing the argument to provide an order for appropriate. Where is the affidavit?
My lord, it was filed on 29/1/2021
Where?
in 2585 Sanjeev Sri Sanjeev Nath.
I don't find it. In whose affidavit? Where it is?
Affidavit in opposition on behalf of my lord GMDA, my lord, the town planner.
It is not there.
My lord, there's a copy here.
On the number.
2585.
Respondent. On 29/1/2021,
Yes, my lord.
140. Yes.
Yes, my lord. My lord, now I may take my lord to paragraph 6, my lord. May I read it on? It further to be stated in
The
a
builder has submitted proposal for issuance of a part occupancy for residential 7 blocks which are under process regarding complaint lodged by the petitioner against when so the issue of closing of the exit is under consideration of the part. In the building drawing for proposal and exit. So the government is taking action.
yes, my lord.
Then why you have no grievance against the respondent number 2 also?
No, my lord. My lord, I've been again reiterating what I've submitted, my lord. While this petition was we filed
Now
this-
everything has happened.
now this affidavit has also been filed. It has taken that our representation that was our issue. It is absolutely true, and that is why they have given the same thing that we have stated. Now, therefore, my representation in a way, representation respondent number 2 has been considered. But the only thing is my left is respondent number 3, where my lord may just give my representation be considered by the DC. With
So
regard-
we are now left with 3.
only one, yes.
Only 3.
Yes. So
So
my lord, now
2
what
and
is-
4 is done.
Yes,
Yes, 3.
Regarding lordship, sale permission lordship, according to our instructions, we have not received any applications for sale permission lordship.
So my lord,
This is an instruction.
no, my lord,
at the time
this
of
is my
final-
representation. In my representation, I've clearly stated, my lord, just go to my representation.
No. Tell me,
Yes.
you let me not go into it. Tell me, what is the representation?
My lord, my representation is this, that they should consider with regard, my lord may just see, my lord.
Have you submitted your
Yes.
sale permission
No,
application?
my lord, we have what has happened, as per our agreement.
Mr. Sharma,
Yes, my
I am
lord.
asking you a specific question. Have
Yes.
you submitted the sale permission application?
My lord, let me just elaborate it. only.
No. I am into a simple thing. Have
Yes.
you submitted the sale permission application?
The builder had taken money from us. They had taken everything from us, saying that they would submit it. And we were
Understood,
and
but
we-
have you submitted the sale permission
as
application?
per the knowledge of, as told by the builder, they have told that they have submitted.
As of now, you don't know.
My lord, as per the agreement, they took money from us on a legal documentation charges and saying that they would get us permission. So we hand over everything to them. And the builder said they
You
would carry
file
out
a
the work.
suit. You file a suit against them for recovering that money, but have you submitted the application?
My
I'm
lord,
on that.
on a personal level, my lord,
Absolutely.
my lord, as of personal level, we have given a representation to the GMDA.
No. GMDA, DMC, and nothing will happen. Have you submitted the sale permission application? Because without that, the DC doesn't come into the.
My lord, the
The
DC,
DC will only come in when you submit. If they don't submit or you don't submit, the DC is not bothered whether he does or you do.
my lord,
Now, whether you have submitted or not,
my lord, on that, my lord, the issue is in a different way, my lord. There is a joint meeting that has happened that I have annexed here between, and that is where the DC got involved, my lord. And that is why, my lord, we just look into it. It is not a matter where that I have not submitted. It is matter even after
no,
submission.
if you have submitted, tell me when did you
Yes, I
submit?
have submitted.
Where?
In the DC. And there,
Show me
because
that. Where is the number? There is a number being given. Where is your statement that you have submitted the application for permission? Yes, Mr. Counsel. For the respondent, which respondent you are?
Your lordship. Your lordship, the main crux of the matter is that they have come up over this with the representation. There was a dispute regarding an exit gate, your lordship. And already the honorable court has directed us and we have opened the exit gate and we have maintained the status quo, your lordship. Now regarding to the maintainability of the read, your lordship, we have challenged it because there was a arbitral clause, your lordship. And according to section 8 of the Arbitration and Conciliation Act, it restricts when there is arbitral clause, you cannot prefer to the read jurisdiction, your lordship. They could have set with us with the amicable settlement. We are ready for that, your lordship. We are cooperating there regarding the rest of the grievances.
No, but
Yep.
Mr. Counsel, tell me, can the arbitrator direct the GMDA issue an occupancy certificate?
No lordship, no lordship.
Can the arbitrator direct the deputy commissioner that look here, he has submitted a representation, consider it? Can he do so?
No lordship. We agree to that, your lordship.
Then what remains? Whatever he is asking is within the bounds of an authority to comply. How do you bring in our section 8 or any other provision out there? Those things don't. But I'm asking you, 2 and 3, as you got 2 and 4, nothing is there. But what about 3? Have you submitted the application on their behalf for permission?
Your lordship, we are ready to submit it to give them self permission, your lordship. We do not have any objection. But they will have to pursue us, your lordship. They did not pursue us.
no, that is absolutely there is
Mr. Sharma, don't unnecessarily make it complicated.
We are ready to provide it, sir, your lordship. We do not have any objection regarding giving the sale permission to them.
No.
Sale,
You,
Mr.
Counsel,
sale date,
you
lordship.
can't give the sale permission. The
No,
sale
no, lordship,
permission
lordship.
has to be applied,
Lordship,
where
sale,
it has
lordship.
to be signed by both the
Both the
parties,
parties, your lordship.
owner, and you are the owner.
Yes.
You are the owner and have the power of attorney. So you have to do it, file an application along with him as the vendee. That is, when are you going to do it? Thereafter, the DC will take a call. The DC doesn't come in the picture unless you file it. When are you going to do that?
Your lordship, let us seek
Whenever
for
he approaches.
let us seek for amicable settlement. We are ready to
My lord, this,
Okay. Then in that case, I dispose it of taking into account that you are agreeable to submit the DC permission for DC permission.
Lordship.
So with DC permission, and anything happens thereafter, if he doesn't do so, go to arbitration. Matter over. Heard Mr. S.P. Sharma, both the learning counsel for the petitioner. Mr. Your name?
P.S. Vishwas, your lordship. Your lordship,
Mr. Who appears for the government's
I'm for respondent number 3, Lord.
respondent number? No. Who appears for one? Town planning.
I'm appearing, Lord. I'm for 1 and 3, Lord.
Mr. N. Goswami appears for the respondent number 1 and 3. Mr. Yes, your name?
Respondent number 2, my lord. S. Sutia, my
S. Suti appears on behalf of the respondent number
2, my
2. Who appears for RERA?
my lord,
No RERA people.
do not appear, my lord.
Huh?
Just for Dinath is appearing, Lord. Yes, file Ugalat.
Okay. None appears on behalf of the RERA on court. Respondent number 4 on court. Mr. S.C. Biswas.
P.S. Vishwas, your
P.S. Biswas appears for the respondent number 5 and 6. Both the writ petitions are taken up for disposal. What is the stage? Motion, admission, hearing, what?
My lord, they had filed a stay vacating application.
It is okay.
Admission, my lord. The proceeding
No
has been
notice.
completed.
Has the notice been issued?
Yes, my lord.
When?
On 25/6/2020, my lord.
When?
25/6/2020.
Okay. The instant matter has been listed for admission. From a perusal of the writ petition, it transpires that the grievances of the petitioners in both the writ petitions has been taken up for admission. The petitioners herein in both the writ petitions claims to be claims to have entered into agreements for sale with the respondent number 6. In respect to for purchase of flats in Agrim Vista, there's blocks 6. Is it both?
Yes, blocks. One is block 6, my lord. Both blocks.
Both blocks.
Flat number will be different.
The grievances of the petitioners is that the respondent number 6 have not obtained the occupancy certificate from the Guwahati Metropolitan Development Authority.
Because it's in Bharapur.
And the consequence thereof is that the petitioners are not in a position to register the deeds of sale. It is the further case of the petitioners that there has been major deviations to the building plan. For which representations have been submitted to the, what is RERA, full name?
Real Estate Regulatory Authority.
To the Assam
Real Estate Regulatory Authority.
Real Estate Regulatory Authority.
My lord, our complaint.
However, no steps in that regard was taken by the said authority. It is the further case of the petitioners herein that the Deputy Commissioner in terms with section 21A of the Registration Act 1908 insofar as applicable to the state of Assam, is required to grant the no objection certificate for which representation was also submitted by the petitioners. Before the Deputy Commissioner, Kamrup Metro. It is on account of the non-consideration or the delay in consideration of the representations. The petitioners, being aggrieved, have preferred both the petitions. It appears on record that pursuant to orders being passed by this court, on 25/6/2020, whereby directions were issued to the respondent number 2, that is the GMDA, and the respondent number 3, that is the Deputy Commissioner, to look into the grievances of the petitioners so that the exit gate is properly maintained open and kept in the workable condition to deal with an emergency situation which may arise in near future. It is also relevant to take note of that both the writ petitions were filed same date
Same date.
on 11/6/2020, when on account of the first wave of COVID, various restrictions were imposed and respondent number 3 authority, respondent number 4 authority was not functioning. Next. It, however, appears from the order dated 5/11/2020 of this court that the additional senior government advocate informed this court that the RERA was functioning and notice dated 29/9/2020 have been issued to the respondent number 5 against the complaint made by the petitioner. Where's the RERA's order?
My lord, RERA order is not there. It's because it came very recently, last week, last to last week, RERA has passed the order.
What order?
They have RERA has given has heard a complaint petition and has given an order under the complaint petition. So
It is relevant to take note of that Mr. S.P. Sharma, the learned counsel appearing on behalf of the petitioners, duly submit that recently the RERA, the respondent number 4, pursuant to the representation, have already passed appropriate orders ventilating their grievances. Next. It further appears that on 29/1/2021, the town planner of the GMDA had also filed an affidavit in opposition. Wherein at paragraph number 6, it has been categorically mentioned that that pursuant to the complaint lodged by the petitioners against the respondent number 6, the issue of closing of the exit is under consideration of the part occupancy proposal. It was mentioned that in the build drawing for occupancy proposal, the entry and exit of the sites are shown, but as in the site observation, the exit is blocked by the builder. It was further mentioned that there is a provision of opening the exit and the commercial block is between the entry and exit, which is not yet started. Further to that, it was also mentioned that in the original approved site plan, the open space between block 5 and Roman 5 and block 6 is shown as the garden area. But as per the submitted build drawing for the occupancy proposal, this open space is shown as badminton court, children child play area, half basketball court area, and also a swimming pool at the terrace. Floor of block 6. It was further mentioned that during the site inspection, certain deviations were also found, which were number A, total excess bracket deviated bracket close area in floors 368.10 square meter, block 7. B, parking deviation block 1 to block 7 bracket block 1 to block 7. I, still parking. What is this still parking? What is this term? Yes, GMDA. What do you mean by this still parking? STILT. No idea. Just filed it for the sake of it. Still parking is equal to 101 numbers approved. Still parking is equals to 95 numbers maintained. Deviation is equals to 6 numbers. Number 2. Over अपने parking deviation B will report it. এই ইয়াত page 142 কেনেকে দেখা আৰু বাকিখিনি লিখি দিয়ক open parking is equal to 204 open parking maintained so and so and so total deviation of parking is equals to 64 numbers যেনেকে আছে it was further mentioned that the deviations were observed in the common areas by way of construction in the terraces. Further to that, it has been mentioned that the process of part occupancy proposal is under consideration. And all the deviations shall be dealt at the time of disposal of the part occupancy proposal as per the provisions of the building bylaws in force. From the said affidavit, therefore, it transpires that the respondent authority, respondent number 3 authority, you are 3 GMDA? No, respondent number 2 authority have already taken steps in pursuance to the representation so submitted by the petitioner. Next. As regards the representation which is required to be submitted, as regards the representation so submitted by the petitioners for grant of permission to the Deputy Commissioner, Kamrup Metro, Kamrup Metro, the learned counsel appearing on behalf of the respondent number 3 on instruction submits that the DC cannot act on the same representation without there being an application seeking sale permission, seeking the no objection certificate. Now, what do you mean by this thing, this amendment which happened in 2022? What is the effect of the amendment? (2021) amendment. Do you have the 2021 amendment? 21A when it was brought in? No idea?
My lord, is it regarded to that occupancy certificate?
Sorry, Mr. Now, as per the latest amendment, Mr. Gustami, as per the latest amendment, you don't require for residential apartments. NOC is not required.
Now it is required, Lord Ship.
No, this is the amendment which has been brought in.
Subsequently, it is also changed, as per my knowledge, Lord Ship.
Huh?
Subsequently, it is also changed. Now, NOC is required. Lord
When this has happened?
Ship.
This is of 2022.
Subsequently, it isn't changed as per knowledge. As per my knowledge, Lord Ship, it is subsequently changed.
When?
Now it is NOC is required, Lord.
No, for a residential apartment, you kindly see this document.
Lordship. Just subsequently this will change. Lordship.
This has been stayed.
That changed, Lordship. Now NOC is required for a flat, residential flat, Lordship.
Where?
But I have to.
From here, it does not appear.
Like it, Lordship. Like it,
So, lekho.
like it.
Be that as it may, it is relevant to take note of that section 21A was inserted to the Registration Act 1908 by the Registration bracket Assam Amendment Act 2009. The said section 21A, so inserted, is reproduced here in under. From a perusal of the said registration, from the perusal of the said provision, it is apparent that notwithstanding anything contained in the other provisions of the Act of the Registration Act 1908, no non-testamentary instrument relating to immovable property shall be accepted for registration unless the Deputy Commissioner of the concerned district issues a no objection certificate containing the description of such immovable property to be transferred, and also such other no objection certificates which are required to be issued by the Deputy Commissioner or any other authority under any law for the time being enforced, or under any executive instruction or order, etc., issued by the state government. The proviso to the said section makes it clear that the no objection certificate shall have to be issued within a period of 30 days from the date of receipt of the application. And in case no objection certificate is not issued within the stipulated period of 30 days, a speaking order with reasons thereof shall be issued to the applicant within the said stipulated period. It, however, appears that Section 21A was further amended by the registration bracket Assam Amendment Act 2021, which received the assent of the President on 15th of February 2022. The said act, being relevant, is reproduced herein under. From Section 2 of the said Amending Act of 2021, it reveals that the words, inverted comma, except for house, comma, flat, comma, residential apartment, comma, commercial building or any construction of structure erected on a plot of land, inverted comma closed, was required to be inserted between the words immovable and immovable, inverted comma, and inverted comma shall be. Immovable property, inverted comma, and shall be, inverted comma, which appears in the third line of section 21A. Full stop. Therefore, from a perusal of the said amendment, therefore, from the said amendment which was brought into effect on 24th of February 2022, the no objection certificate so required under section 21A of the Registration Act 1908 insofar as the state of Assam is not required for house, flat, residential apartment, commercial building, or any construction or structure erected on a plot of land. Mr. Gusami, there is no other amendment.
One notification has been there, Lordship.
When?
6 in December.
6/12/2022.
In December, they have amended it. Because it's a RERA order also, it has been reflected about this. Even the GMD is aware. This now the NOC is required for registration of flat.
Where is it?
And this notification is there.
6/12/2022.
If this is after the Supreme Court judgment, my lord, I have sent it, my lord, after.
You have given me some order here.
No, I have sent it in online. My lord, I did not wanted to interrupt. There is a Supreme Court judgment with regard to this, that flat buyers requires. And the notification is after that.
But that notification is not there. How come by way of a notification means whether there was again an amendment to this? There has to be an amendment. Nowadays, is it so easy to get the amendments done from the President of India?
There is a notification by the government.
Because you need the assent of the President for doing.
But there was this notification that was there.
No, we'll keep it like this. You do whatever you like.
My
No,
lord,
as of now, there is no required for apartments.
No, my lord. In fact, there is.
You hold it, then you get the sale deed done.
No, my
He's
lord.
going to execute it.
But now even my lord, this being the order, after this notification is there, and there's a Supreme Court order also that NOC has been required. My lord, I have sent it. That has. How can they would not be able to obtain the? I would be no way, my lord, because the government is not going to give after this notification has been there.
So the
They-
government
my lord-
notification, he has failed to produce it.
My lord, the respondent being fair to the court, they should submit that they even did registration of some of the flat, but now they are not able to do it after this notification. They should be fair to the submit to the court, my lord.
Then file contempt. Where is it required notification? Which Supreme Court judgment?
My lord. My lord, Devasis Sinha and others versus RNR Enterprise 2023 SEC Online SC 120, my lord.
So you mean to say after that it has happened?
No, my lord, I had, when this notification, this was a February 9, 2023, the judgment. The notification was of 6 December
Then,
2022. And this,
so you mean to say that the government became more clever than the
no,
Supreme
I'm
Court?
saying that I
Which is
relied on this
always
judgment.
unlike.
My lord, this judgment was there with
Hmm.
regard to. Wait, I'll repeat it. I'll repeat the citation again, my lord. This is 2023 SSC Online SC 120.
Mr. Gustami, you are of no help.
I'll
Huh?
send you a
You
notification.
people appear in the court just to show your face. You are of no help. You don't know head or tail about this departments. Yes, give it to me. What is the name?
My lord, if my lord is using SSC Online, it is 2023 SSC Online.
Mr. Counsel, give me the name.
Devasis Sinha and others.
D
BASHIS.
DEBA.
DEBA. Yes, ma'am.
H.
DEBA SHIS Sinha SHINHA and others.
This is not an amendment. It is an SOP. Devashish, what?
No, I have sent the judgment, ma'am. Code 17.3.
This is not an amendment. Neither it's an ordinance. It's not an ordinance also. I hope your government knows that there is a requirement of an ordinance to override, as has been done in the Delhi government. If within the period there is no legislature sitting, then obviously there has to be an ordinance, not by way of a notification or an SOP. Yeah, you are just following standard of SOP. Can this notification have any value? Yes, where does it say?
Madam, paragraph 19. Consequently enough, the case NCD has to refer to subsection 2 of section
Oh,
4.
where? Curiously.
Paragraph 19, madam.
There is no consequently. Curiously.
Curiously
then?
enough, that NCDRC referred to subsection 2 of section 403 of KMC Act only to permit the respondents to wriggle out of such obligation and arrive at a complete erroneous finding that no deficiency service could be attributed to the respondent since both the respondent and appellant had acted in violation of law. True, it is the appellant ought not to have taken position ground not to direct the respondent to apply and obtain the completion certificate as required by law. The mere fact that the flat owners were being assessed by KMC affords no reason to respondent of breaching section 4 by right with 19. Of course, once a completion certificate issued by the KMC upon conducting appropriate inspection and test a building that has since it would stand to reason the same amounts of certification a building does not suffer from any violation of the building plan sanctioned for the purpose under section 309 of KMC Act, or that its construction quantity is not of the desirable level for which it is unsafe for human habitation. We are constrained to observe that the respondent have been left off by the NCDs in a matter contrary.
Where?
My lord, there, my lord. However, that was not a valid completion certificate.
Why are you into the completion certificate? I'm only on the question of requirement of NOC.
My lord,
Where does the Supreme Court say anything about the NOC?
where my lord, the NOC will only be issued. NOC will only be issued when they get the completion certificate.
I'm not on that. I'm only asking about the NOC. Now I am on the question as to whether an NOC is required or not. Where does the Supreme Court say?
Well, that was regarding completion certificate.
Then unnecessarily why you make? Next. Don't make unnecessary submissions. Mr. Therefore, it would be seen that there is no requirement of a no objection certificate. From the Deputy Commissioner, Office of the, from the Deputy Commissioner, in terms with section 21A, in view of uh, 21A, in respect of house, flat, residential apartment, commercial building, or any construction or structure erected on a plot of land. Be that as it may, Mr. N. Goswami, the learned counsel appearing on behalf of the respondent number 1 and 3, places before this court a notification dated 6/12/2022. The said notification, a perusal of the said notification shows that the governor of Assam was pleased to frame a standard operating procedure, SOP, pending promulgation of the registration bracket Assam Amendment Act 2022, which was passed by the Assam Legislative Assembly in its monsoon session and awaiting for the presidential assent. The said notification Constitution. In the opinion of this court, cannot override the provisions of the registration bracket Assam Amendment Act 2021. The said notification. Inasmuch as if the said notification dated 6/12/2022 is given an overriding effect to the provisions of the registration bracket Assam Amendment Act 2021. It shall violate the provisions of Article 213 of the Constitution of India. Which empowers the governor to promulgate ordinance subject to obtaining instructions from the president if the act of the legislature of the state containing the same provisions would under the Constitution have been invalid unless have been reserved for consideration of the president and it had received the assent of the president. Under such circumstances, unless the governor acts in accordance with the provisions of Article 213 of the Constitution, and or the registration bracket Assam Amendment Act 2022 receives the assent of the president, the Registration Act, Assam Amendment Act 2021 shall hold the field. Next. The Learned Counsel, appearing on behalf of the respondent number 5 and 6, submits that he has no that the said authorities have no problem, the said respondents have no problem, have no issues as regards executing the deeds of sale in favor of the petitioners herein. Taking into account that at present under such circumstances, this court therefore directs under such circumstances, this court therefore is of the opinion that the dispute as regards the deed of sale, execution of the deed of sale, is a dispute between inter-party between the petitioner as well as the respondent number 5 and 6. Under such circumstances, the respondent number 5 and 6 as submitted before this court shall take appropriate steps for the purpose of executing the deed of sale in favor of the petitioners in both the petitions. And the authorities concerned and the registering authorities concerned shall register the said deeds of sale unless the governor of Assam promulgates an ordinance in accordance with Article 213 of the Constitution, or the registration bracket Assam Amendment Act 2022 receives the presidential assent in the meantime. It is further observed that in the eventuality that the governor of Assam promulgates any ordinance and or the registration bracket Assam Amendment Act 2022 receives the assent, then the respondent number 5 and 6 as undertaken before this court shall do the needful for processing the permission, for processing the proposal, for getting the NOC as required, if so required. It is made clear that if such steps are not being taken by the respondent number 5 and 6, it shall be a dispute within the contours of the agreement for sale, for which the petitioner would be at liberty to take steps as in accordance with the said agreement. With the above, petition stands disposed.
Hello.
Mr. Goswami, kindly do this order be placed, otherwise you are in more trouble.
My lord, may I just submit as per?
Don't confuse any further.
No, my
Go
lord. One
to
last word, my
division
lord.
bench.
As in accordance with law, my lord, other than the agreement, my lord, please. At the last. As in accordance with law, rather
If
than.
an agreement, arbitration agreement, you have a go by the arbitration agreement. Pending applications, if any, stands disposed.
Highly obliged. Your Honor.
Item 4.
Yes, Mr. Upadhyay.
Matter related to the acquisition of the right of user.
Right of user.
Yes, right of user under this act. The Petroleum and Mineral Pipeline Acquisition of the User in Land Act 1960.
You are asking for staying a gazette?
Yes,
Where is that
Madam, here
gazette?
What happened? The government of India expressed the intention to acquire the right of user in respect of various land for laying a gas pipeline here.
Lordship,
And according to my
petitioners,
land was also acquired. Sir, my lord, the
Lordship, petitioners' basic grievance in this case is
Yes. What is your right?
right,
Who are you?
I am the landowner. I am the
Fantastic.
landowner.
Now,
First
if
notice-
this, are you challenging this particular notification of
Yes.
2021 under what provision? Why?
Challenge because here the notification itself said that you filed your objection.
File your objection.
Yes, I filed my objection.
Then,
Then, my lord, no opportunity of hearing was given. It is my allegation, my lord. Let us they filed the.
but why you are asking for setting aside the notification? That is what you are asking.
I am not challenging the entire, my lord. The
No, what you are saying, kindly
My
come to page,
interest is-
no, Mr. Upadhyay, kindly come to page 28.
Page 28. Yes, my lord. 28.
Read the prayer,
Yes,
read it.
yes, sir. This 11th paragraph upon the respondent to so cause as to why the direction or order in the nature of such release should not be issued to pass and set aside the gazette notification. 5 such number dated 21.
Then-
by this, my letter was acquired.
So, if
My-
anything is there,
Yeah,
take steps.
my
As per this act, there is an act of the.
Lordship, here what happened, I filed my objection. They ought to have
Mr.
given-
Upadhyay, that is not your case here.
Yes, that is-
Your prayer is for setting aside this thing. If they don't do it,
Without
then you
setting
have to
aside.
bring your case within the contours of that.
That is the final order, your lordship.
Which
That
one?
is the 21, 2021 is the final order.
Hmm.
Final order of the government of India.
Yes.
I filed my objection before the competent authority.
Hmm.
And the competent authority ought to have given me opportunity of hearing. My allegation is that no opportunity of hearing is given, but in the notification, in that particular which I have challenged, there especially mentioned that the objection,
You have the copy of that act?
yes, ma'am.
What is your objection?
Objection, my lord, I have got my residential house, etc., where the pipeline is proposed to be laid.
Lordship, dear objection, we have filed our preliminary affidavit on 2/12/2021, wherein it was annexed. Lordship, may kindly
Any person interested in land may within 21 days from the date of notification under section 3(1) object to the laying down of every objection here that be made on and this is under section 6, the declaration.
Yeah.
You are challenging the declaration.
Declared.
So you say that 5 was not complied with.
Yeah.
Isn't it?
But here, my lord, affidavit in opposition is filed by 3 and 4. They said that opportunity was given, you were heard. But the thing is that they admitted that on the day of hearing, I was not present. They said that notice was issued to you, but you did not appear, so your objection was disposed of.
Failed to be
This is
present
their
before
case.
the competent
if peruse the their objection, Lordship, their only ground that the state land is the agricultural land.
Huh?
Their state land is the agricultural land from which they are earning their bread. Lordship, therefore, they have filed this objection. And accordingly, we have forwarded the notices and accordingly they have duly received, and thereafter hearing was took place. They did not turn up, and accordingly order was passed. That order is page 15, Lordship.
Huh?
Page 15 of our affidavit.
Your affidavit. 51,
we have encloses the notice, Lordship.
page 15.
Yes, Lord. 15 of
There
our
are many notices.
affidavit.
How many petitioners are here?
Two petitions. Bharati Busumati and another.
Why are other notices are given?
Lordship,
one?
page 11. Lordship, page 11.
Your affidavit,
Yes.
3 and 4.
Yes.
You have filed a preliminary affidavit.
Yes, Lord. Because notice not issued, Lordship, in this.
Okay, very well. Page?
Page 11, Lordship.
There is no page 11 here. You don't have page 11.
File on 2/12/2021, Lordship. Preliminary.
Yes, 2/12/2021. No page 11. What is the annexure?
Annexure 3, Lordship.
That notice in Asmis?
Yes, Lordship.
Yes, tell me.
Lordship, below, Lordship, brother has received, Lordship, Vishnu Hazuari, and Lordship, page 13, the petitioner 2 has received.
Huh?
Page 13, Lordship, Assamese.
He has received.
Yes, Lord.
Then
Lordship, thereafter order, Lordship.
order of objection. Peruse the written objection filed by so and so against the notice under the objection comprises of the following. The petitioner is developed irrigation system for agricultural work, including cultivation on the scheduled month, and as such it clearly mentioned in the notice to select that the land after laying by used by due compensation.
Since their objection, Lordship,
The land will, the pipeline will go underneath.
and pipeline already laid. Lordship,
My
Lordship
immediate
was there.
objection, my lord. As a whole, I'm not telling that there should not be a pipeline. It is in public interest. I also know.
Then
Here only the apart. It should not be nearby my village residence.
Huh?
Nearby my residence. Residence, and there is a village, my lord. If pipeline is laid adjacent to the village, it may expose the.
And no one get, Lordship.
wait,
It will cause. It may cause the mind or peril in future. That is my.
it may cause.
It is a danger, my lord. If
Mr. Counsel, the entire, you see the Borsapara and all these areas, these are all situated next to the pipeline of oil. Entire stretch, starting from Jalukbari and ending to the entire thing. Even now, these places, what do you call the Assam Administrative College, is next to the pipeline.
petroleum line. That is a petroleum. That is a petroleum.
What is
But
this
it
line?
Yes. My lord.
So,
Gas is more chance of being leaked.
unless James Bond doesn't come, nothing is going to happen.
But
Only
my
in
lord,
that
in
movie,
that
James
event,
Bond movie, it has happened.
Yes, my lord. In that event, my lord, let directed to pay the compensation.
They will. They are going to pay the compensation and in terms with the law.
Yes.
Nothing happens.
Yes.
Heard Mr. P. Upadhyay, the learned counsel appearing on behalf of the petitioner. Mr. K. Kolida
Yes,
appears on behalf of the respondent number
3 and 4, Lordship.
3 and 4. Where is Mr. S.S. Roy? Not there. No government. Union, madam, you appear for union? Okay. None appears for the Union of India as well as for the Ministry of Petroleum on call. The petitioner have challenged the notification dated 21/2021 issued by the Ministry of Petroleum and Natural Gas in exercise of the powers under section 3(1) under section 6. Where is the notification?
Case 53, Lordship.
Where is the exercise under exercise under exercise under section 6(1)
Yes.
of the Petroleum and Mineral Pipelines bracket Acquisition of Right of User in Land Act 1962. The entire case of the petitioner hinges upon that there was no compliance to Section 5 of the said Act of 1962, as an opportunity of hearing was not given to the petitioner. It appears from the record that a preliminary affidavit in opposition was filed by the respondent number 3 and 4. In the said affidavit in opposition, it has been specifically mentioned that that pursuant to the objections so filed by the petitioners herein, due notices were issued by the competent authority on 8/10/2020, thereby fixing the matter on 14/10/2020. However, in the case of the petitioner number 1, his brother, and in the case of the petitioner number 2, himself, after having received the said notices did not appear before the competent authority. It is under such circumstances, the competent authority have therefore passed an order on, what is the date? Mr. Counsel?
Case 15, Lordship, 19 November 2020. In
Where?
respect of the petition number 2, Lordship. Like last line, given under my hand and seal, please.
Have passed order on
Both-
19th of November 2020, as would appear from Annexure 5 and 6 of the said preliminary affidavit in opposition. Under such circumstances, the question of violation of Section 5 of the Act of 1962 does not arise. The learned counsel for the petitioner, however, submits that as the petitioner is entitled to compensation, as have been stated in the orders dated 19/11/2020 in Annexure 5 and 6 to the preliminary affidavit in opposition, the authorities should pay the compensation to which the petitioner is entitled to, isn't it? The learned counsel, appearing on behalf of the respondent number 3 and 4, submits that if till date the compensation has not been paid, the same shall be duly paid. As expeditiously as possible. Full stop. Taking into account the above, this court therefore finds no ground to interfere with the notification dated 21/2023, 21/2021, subject to the observations that the petitioner would be entitled to compensation, and if the same have not yet been paid, the same be paid as expeditiously.
One observation, they have to furnish the required documents, Lordship, for releasing the compensation.
The same be paid as expeditiously as possible upon the petitioner furnishing the necessary documents in that regard.
Obliged. It's on alleging that though they are shortlisted, but they were not given any contact, Lordship, in respect of hire NIT issued by the Oil India Limited for hiring the buses, Lordship. But as per my instruction, all the petitioner has got the contact, Lordship. And therefore, we have submitted in the initial stage that this is a premature requisition. All the requisitions have got. Concerning for 6961/2000, two requisitions are here, Lordship. Today, 6961 listed, Lordship. name of the petitioner and their contact number exhibited also there.
In practice,
No.
Art Mr. Arpukan, the learned counsel for the petitioner, Mr. K. Gulta appears on behalf of the Oil India Limited. The learned counsel appearing on behalf of the petitioner submits that as the petitioners herein have already been awarded contracts, nothing survives in the instant writ petition, and the same has become infructuous. Accordingly, the petition stands dismissed as in.
Obliged.
7.
In this petition, I have made two challenges. One is the suspension and another the judgmental proceeding, my lord. On 19/5/2023, suspension has been revoked, my lord. And this is the order, my lord.
Revoked?
Suspension order was revoked, my lord.
Then?
And the departmental proceeding is also under challenge, my lord, in this petition, my lord. And the only ground is that, my lord, the appointing authority, which is the disciplinary authority, is not initiated the departmental proceeding, my lord. It is the only ground.
What is the ground?
The authority which is initiated the departmental proceeding, my lord, that is not the appointing authority or the disciplinary authority, my lord. My appointing authority is, my lord, Assistant Inspector General of Police, my lord, and the departmental proceeding has been initiated by the Superintendent of Police, Railway Police, my lord.
What is the status of the year? The
Uh,
departmental proceeding?
Presently, my lord, inquiry commission has inquiry officer has been appointed, my lord, and a letter was furnished to me to apprise them whether I am inclined to give any defense witness or not, my lord. That is the status.
Where?
That letter is recently, my lord, has been sent to me, my lord.
No, these are not there.
In the writ petition.
Where the departmental proceedings initiated?
Page number 93, my lord, is the show cause notice, my lord. First show cause
It has been issued by
notice. Superintendent of Railway Police, my lord.
Superintendent of Police.
Railway Police.
So you say that he is not the disciplinary authority.
My appointment is the, my lord, is at page number 69, my lord. Office of the Director General of Police, my lord. It's the Inspector General of Police, Administration of.
So your joining report is wrong.
I was posted at one in the under establishment of one in the.
Are you saying that the order by which you were absorbed against the existing vacancy is wrong?
No, my lord, I am not saying so.
But it has been done by a wrong person, a person who had no authority.
Because my
Kindly
lord,
come to page 73.
73. My lord, after my appointment, my lord, I was posted in the Railway Police, my lord. and
So
this is the
we
report submitted by-
hold that this order is wrong.
So after my joining, my lord, this information has been furnished, my lord. Because in persons of memo number that is so and so of the Act 70, my lord.
So are you saying this accordingly, they are absorbed against the existing vacancy of EVC and allowed to draw their regular salary, pay and allowances as admissible under rule is wrong?
No, I'm not saying so, my lord.
Then,
After my appointment, my
but it has been done by the Superintendent of Railway Police.
because Superintendent of Railway Police also under the establishment of my lord, Director General of Police, my lord. This is one of the branch of the Assam Police, my lord. It is
Then?
subordinate to the Director General of Police, my lord. This is subordinate, my lord. My submission is that.
In your reply, have you raised that issue?
In my reply, my lord, unfortunately, I have not raised this issue, my lord. In my reply, my lord, I have not raised that issue, my lord.
Then,
But even that is the statutory provision, my lord. So
no,
this
but if you have not raised that issue, why should this court at all interfere? Go there, raise the issue. They may think of reconsidering it.
Then, my lord, an opportunity may be given. I may raise this issue before the proceeding initiated, and that may be decided by them, my lord.
You raised that issue. I will withdraw
Liberty
it.
may be given, my lord.
Third, Mr.
I may.
And so the learned counsel appearing on behalf of the petitioner. Miss M. Deborah appears on behalf of the respondent number
125. 1, 2, 3, 4, 5.
125. The petitioner herein have challenged the departmental proceedings initiated on the basis of the show cause notice dated 8/2/2023, as well as also the order of suspension dated 1/11/2022. During the course of the hearing, the learned counsel appearing on behalf of the petitioner submits that the order dated 1/11/2022, by which the petitioner was suspended, was revoked. By an order dated 19/5/2023. The same is kept on record and marked with the letter X. The further case of the petitioner herein is that the authority who have issued the show cause notice dated 8/2/2023 is not the appointing authority of the petitioner. And as such, the said show cause notice, or for that matter, the entire disciplinary proceeding so initiated against the petitioner is required to be interfered with. It further appears from Annexure 15 of the writ petition that the petitioner had submitted the statement of defense before the authority who issued the show cause notice. There is no mention whatsoever in the said reply, in the said statement of defense, that the show cause notice so issued, show cause notice oblique the memorandum of charge so issued, was not by the authority and authorized to do so. Taking into account the same, this court does not find it relevant, does not find that the petitioner have been able to make out a case for interference under Article 2 to 6 of the Constitution. However, this court gives the liberty to the petitioner to file an additional statement of defense within 10 days from today, if so advised, to take the ground that the authority who initiated the disciplinary proceedings was not authorized to do so. Above the petition stands.
Obliged.
Huh?
If I submit that,
Then if they don't, then you have good reasons for filing appeal.
Obliged.
Eight.
Yes, madam.
May I please your lordship? Mr. Mazumdar is on exit court number 1.
Don't worry. You do your matter. Don't think about what their senior says. What do you want?
The petitioners are serving in CRPF 175 battalion, and in the year 2019, the respondents are granted risk and hardship allowances. And suddenly, after
4 years on dated annexure 6, dated Impune Order 17/02/2023. The respondents want to recover the risk and allowances. So
Yes, Mr. Dutta.
My lord,
This matter is
similar case was
that
passed,
matter pertaining
Ganesh
to
Prasad Tripathi.
huh?
In Ganesh Prasad Tripathi case.
Yeah.
Sir,
There also,
instruction-
no, because your specific stand is they are entitled to some other. Is this the Karbi Anglong?
yes, 4379.
The Karbi Anglong, no?
Yes.
21.
So there was a proposal which has been given out there
Yeah.
to the effect that they should also be getting this here. But your stand is specific to the effect that they are getting some other things which he has not accepted.
Now there is a question that they belong to grade 3, my lord.
Yes, great.
They belong to grade 3. Have they retired?
No, they are still serving in that.
How long? When was this period?
2000, it came into effect from 2019 to January 2023.
This is not far off.
And
Rafiq Masih would only be involved for a long time.
long time.
According to them,
And the instruction is necessary because whether they was deployed in a hard area or not is the question.
Then if instruction, then the stay is also necessary. Don't you think so?
I'm doing the test check.
Because there are numbers of good numbers of petitioners here.
7.
You pay court fee? Court fee paid. Nine, 14, 26, 35, 52, 56, 70.
72, my.
7.
Third, Miss
T. Sharma.
T. Sharma, the learned counsel appearing on behalf of the petitioner, Mr. A.K. Dutta appears on behalf of respondent number 1, 2, 3, 4,
All the
5, 6, and 7. Issue notice making it returnable on when?
My lord, 4 weeks, my lord.
Issue notice. We'll have it after July. You file your affidavit.
Yes, my lord, we shall file. We shall file if instruction come to me.
No, I picked it in the, immediately after vacation. Because we are almost, only 1 month is left in June. You are asking for 4 weeks. So after from 1st of July to 17th, it is closed. We have it on 24th of July. Issue notice making it returnable on 24th of July 2023. The petitioners are directed to take as Mr. A.K. Dutta duly represents the respondent numbers 1 to 7. Extra copies of the writ petition be served upon him by today's 24th. 24th, no? By 26th of May 2023. The case of the petitioner herein, of the petitioners herein, that by an order dated 17 to 2023, there is a direction issued by who?
DIG.
By the group center Silchar to make recovery. The risk and hardship allowances so given to the petitioner during the period from 2019 to January 2023. It has been brought to the attention of the learned it has been brought to the attention of this court that the petitioners herein are entitled to the risk and hardship allowances in terms with the office memorandum dated 31st of July 2017. It is, however, the case and as such, the question of recovery does not arise. The Learned Counsel for the petitioner further drawing the reference to the judgment of the Supreme Court in the case of State of Punjab versus Rafiq Masi, whitewasher reported in so-and-so, submits that as their petitioners are grade 3 employees, the recovery so made ought not to have been allowed. The recovery so made is iniquitous and impermissible. On the other hand, Mr. A.K. Doctor, the Learned Counsel appearing on behalf of the respondent submits that the risk and hardship allowances which the petitioner were given ought not to have been given in view of the annexure to the office memorandum dated 22/2/2019, wherein the district of Karbi Anglong is not included to come within the for the benefit of is not included. And as such, the petitioners were not entitled to the risk and hardship allowance. He further submitted that the petitioners are otherwise entitled to that allowance is what? They were otherwise entitled to, there is another allowance, no?
The government has specified the area in which they are entitled.
No, there is another allowance they get it.
They opted for special duty allowance,
Special duty.
ration money allowance.
The petitioners were only entitled to the special duty allowances. And as such, the respondents have rightly taken the decision to make the recovery. Upon hearing the learned counsels for the parties, and also taking into account that similar litigations are pending before this court as regards the entitlement of the risk and hardship allowances to those persons who were posted in the district of Karbi Anglong. This, as well as the judgment of the Supreme Court in the case of Rafiq Masi Supra. This court, till the next date so fixed, stays the action of recovery as mentioned in a states the communication dated 17/2/2023 insofar as steps were to be taken for the purpose of recovery to be made from the petitions. List the matter along with that matter.
Ganesh Prasad Tripathi is already disposed of by your lordship, my lord.
Oh, what happened? What did I do?
Some benefit was given, but I couldn't.
Okay, list the matter till the next date.
Much obliged.
9. Yes, Mr. Mohan.
Lordship, this matter pertains to non-payment of the wages of the petitioner since 2014 to 18.
Non-payment of area salary
Lordship.
from 2014 at fixed wage of rupees 5,000 in pursuant to the engagement letter dated so and so, the release of the petitioner, wages of the petitioner with effect from a month immediately within the time limit as fixed. Yes, madam. You are appealing for whom?
I am for Deputy Commissioner, respondent number 3.
In this matter, I am also, my lord, appealing for the General Administration Department. There, our names have not been reflected, my lord, and we have not been served any copy, my lord. Difficulty, my lord. Just
You
now
have so many standing counsel. How will the poor
lord, just now we
petitioner
have been
know?
informed.
Government has received the copy.
No, we have not received. Our name has
The
affected the cause list also.
finance department will also give it copy.
My lord, for the GAD, my lord, there is a standing counsel, my lord, not the government advocates are not.
No worry. I'm not disposing of the matter. You'll get an extra copy.
My lord.
Heard Mr. L. Mohan, the learned counsel, appearing on behalf of the petitioner. Ms. S. Bolwa appears on behalf of the respondent number
3.
3. Mr.
A. Pukan.
A. Pukan appears on behalf of the respondent number 1 and 4.
One, and only one.
Madam, you are appealing for 3 and 4? Finance and account office of the deputy.
Finance.
No. It is finance and account of the office of the deputy commissioner. It will be under you.
Yes, 4. I
Ms.
can.
S. Bolwa appears for respondent number 3 and 4. Mr. A. Pukan appears on behalf of the respondent number 1. None appears on behalf of the finance on call.
He's here, my lord.
Mr. A. Solia appears on behalf of the respondent number 2 and 5.
3 and 5.
3.
2.
2 and 5.
Issue notice making it returnable on. We'll have it after vacation.
My lord.
On 26th. On 19th of July 2023.
My lord.
As the respondents are duly represented, the extra copies of the petition be served upon them by 26th of May 2023. The case of the petitioner herein is that the petitioner was engaged by the respondent number 3 by an order dated 15/11/2014.
Is 19 law.
At the wage of rupees 5,000 per month. Rate of at the wages of rupees 5,000. That is rupees 166.67 per day with effect from 15th of November 2014. The grievance of the petitioner that the petitioner have not received the salary since the date of his engagement till date. Accordingly, the instant writ petition has been filed. The respondents, more particularly the respondent in the General Administration Department as well as the Office of the Deputy Commissioner, shall apprise this court on the next returnable date as to why the petitioner have not been paid his salary, area salary. Are you still working? That's the salary of the petitioner, including the area salary from 15/11/2014. Then your name has been shown.
My lord, no, well, my name may be reflected, my lord, in the registry.
The registry shall show the name of Mr. A. Pukan, the learned counsel, appearing on behalf of the GAD. Yes. What are you challenging? Or what are you asking?
My lord, the petitioner is the first wife of the deceased employee, my lord.
Huh?
The petitioner is the first wife of the deceased employee, my lord. But
Yes.
the family pension has been granted to the second wife.
Why?
My lord, because
First of all, these people, they don't give family pension. After that, they have given it to the second wife, meaning thereby there is something wrong with you. Seriously. There has to be. Otherwise, why?
my lord, because I am old, my lord.
You are old. You are 65. And how much is the second wife?
40, 40,
And when did your husband die?
2002.
Hmm?
2002, my
2002. And when did the second wife get the family pension?
after that date, my
Then what were you doing for the last 17 years?
my 2022, my
Okay.
sorry, my and actually she second wife is not entitled.
Second wife has been given. You're sure?
Sure.
Heard Mr.
Escape.
S.K. Roy, the learned counsel appearing on behalf of the petitioner. Who appears for whom? How many people?
I am for S1 number 3 and 5 note.
Secondary?
I am.
You, Sharma, appears for respond number 1, 4, 6. Mr. S.R. Borua appears for the Director of Pension
And Deputy Commissioner.
as well as to the for the appears for the respond number 3 and 5. Mr. A. Solia appears on behalf of the respondent number 7. Miss Bancho appears for the respondent number 2. Issue notice making it returnable on 28th of June 2023. Oh, 28. Okay. You take your steps today. Can you take steps of dusty upon the respond number 8? If you take it, then it will be easier and easy to dispose soon. Then you will get the relief.
I can try.
You try. As the respondent numbers 1 to 7 are duly represented, extra copies of the writ petition be served during the course of the day. As regards the respondent number 8, steps be taken by way of registered as well as usual during the course of the day. Further to that, the petitioner is also given the liberty to take steps by way of dusty routed through the registry of this court insofar as the respondent number 8 is concerned, and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner is the first wife of one Abdul Subur Kandakar, since deceased. The husband of the petitioner was the assistant teacher of Jopia High School under BDC Bongaigaon, and he retired from his service on 31/1/2018. During his lifetime, the husband of the petitioner received the other pension as well as the pensionary benefits. Unfortunately, the husband of the petitioner expired on 23/3/2022. Thereupon, the respondent authorities have granted the family pension in favor of the respondent number 8, who is the second wife of the husband of the petitioner. Being agreed, the petitioners have submitted representation before the Director of Pension.
So, my lord, Inspector Vice.
No Director of Pension.
I have also submitted the director.
Submitted representations before the concerned respondent authorities. However, to no avail. It is under such circumstances that the instant writ petition has been filed. The learned counsel for the petitioner has drawing the attention to Rule 143 Romans 2, small Roman 2, and more particularly to Note 1. And the judgment of the full bench of this court in the case of Mustana Padma Thea versus so-and-so reported in 2022 SCC Online GAU 2000. Submitted that it is the first wife who has the entitlement to receive the family pension, and it is only upon the death of the first wife the second or the surviving widows could be entitled to. The Learned Counsel, appearing on behalf of the Director of Pension as well as the Elementary Education Secondary Education Department, shall apprise this court. No, it is they don't have any business. It is you. The Learned Counsel, appearing on behalf of the Director of Pension, shall apprise this court as to why the petitioner have not been given the family pension.
11.
Pension which have been granted.
You want to stay? Don't go. We'll see. Somebody has to survive, na? Liberty is given to the petitioner to mention the matter for upgrading. That is why I tell you, you take the service by way of the state. I can finish it off on that day. You get something. And they will come up with that plea. Look into that. The nomination your husband has done for the second wife. The love is there for the second wife, not for you. And the second wife will come up out there and say that you have divorced. So take care of this before coming on the next. Yes.
Matter pertains to non-payment of remuneration for a particular period.
Yes, these government departments, all corporations are in dire straits. You are entitled to 6,90,000 from Assam Electronics Development Corporation. There is a standing council.
No, man.
Yes, government. Who appears? Show me where it is.
It's 13 mallet. I have
Page
13 mallet. It is
13.
13, one statement.
And close the wrong page. I shall be glad if you can kindly take immediate necessary steps to make payment of my long outstanding funds. Why have you approached after 5 years?
Mallet, here earlier approach also, mallet, but 12 mallet.
Approach High Court?
No.
Why didn't you file? You can't file a suit in the civil court.
Mallet, in fact, mallet 2016 he was working, mallet 2018 mallet here submitted his mallet.
You were working?
Yes, mallet. For the period, kindly see the period, mallet.
I am pleased to join as the chairman of.
Mallet, there is several communication from the several.
No. Show me you are Mohibul Haq.
Ex-minister.
You are the ex-chairman.
Mallet.
Ex-chairman, this is the state of affairs. Huh? You are an MLA or minister.
He is a ex-minister.
This minister, what is your? There is a long pending of my honorarium amounting of rupees so and so. Only for the period from so and so to period for 1 month at 30,000. Show me that 30,000 you are entitled to. What is your basis?
My lord,
there must be some rules, regulations to the effect.
my lord, at least my lord.
Our end.
My lord.
Sorry, Mr. Counsel, this is not a case. You have to go before the civil court.
My lord, at least my lord, what I am saying, my lord, suffering, my lord.
Huh?
Notice may be served, my lord.
No,
this
court, getting a notice is a very difficult thing in this.
My lord, otherwise, my lord, petitioner had submitted.
No, show me that as per their rules and regulations, you are on honorarium.
My lord.
Why? How did you fix 30,000? Show me something. There's nothing on record. You yourself
Yes,
say.
my lord. Yes, my lord.
You admit that. Then
my lord, can be taken next week, my lord. In the meantime, I will obtain, my lord.
you do one thing. I'm not there for 8 and 9.
No, my lord. Then,
You will have it on 9.
my lord, my lord.
Huh?
My lord.
Then somebody may issue notice. I am not going to
No,
issue
my lord.
notice.
Then Friday, my lord. Friday.
Eh?
Friday, my lord.
No.
My lord, only, my lord, I will apply your lordship, my lord.
No, this petition, otherwise you have to show something.
That is why, my lord, I will.
There's nothing on record. You yourself, first of all, what is this honorarium business? Honorarium is
My lord,
out to honor for whatever
yes,
you.
my lord. Yes.
It is just to honor you.
Not-
And you yourself fix, I am entitled to 30,000. How do you fix it?
Probably, my lord, there is a, my lord, norms there. Probably. That is why, my lord, I am
Car rent.
sometime.
Is this court going to decide on the car rent?
My lord, probably there is some provision, my lord. That is why, my lord,
Then what are those provisions you have not brought
my
in?
lord, give me.
That a person is otherwise entitled to, there's a, at the time of appointment or out there, there are certain benefits are being given.
My lord.
Then only this
My
court can exercise the right.
There is a-
Provision is otherwise not there
Kindly
properly.
Friday, my lord, I will apply your lord.
How will you apprise without
My
the
lord,
pleadings are
hopefully will-
not there, no documents are there?
Amtron must have some their rule and regulation. Amtron must have some, my lord, on.
So you are to file it properly. Don't you think so?
Yes, my lord, but
I can't help you otherwise.
My lord, petitioner submitted.
So
RTO.
therefore, I fix it on 9/6. Yes. Some other court may issue notice. At the request of the learned counsel for the petitioner, list the matter on 9/6.
My lord.
I
Oblige.
9. Well, yes, Mr.
My lord, this is also a case of non-payment of salary, my lord. Petitioner is a grade 4 employee in the
Yes.
yes,
Grade 4 employee.
Chagolia High School, my lord.
Then you were appointed in 1989.
89, then I was transferred in 96, my lord, to another, to this school. Then for a limited period, my lord, I was not keeping well. I was suffering from TB.
Hmm.
Then for about 92 days, that leave has been paid in 17, in 17, my lord.
Hmm.
Hereafter, again, I was absent for illness for 11/5/17 to 26/17 for about a month, my lord, for more than a month. Then for that period, leave has not been sanctioned and I have not been paid my salary of thereafter. I made several requests.
From when did you didn't get your salary?
From 11/5/17, my lord.
11/5/17.
Yes. And extra page 15, my lord. Leave for one.
Who is required to pay you that amount? By the inspector of?
Inspector
by-
of schools. Inspector of school has to
Forward it.
forward. No, he has to sanction the leave, my lord.
Who pays? Yes, Mr. Sharma.
Director.
Director of Secondary Education.
Yes, my lord.
Heard Mr. D.P. Solier, the Learned Senior Counsel, assisted by so-and-so. Mr. U. Sharma appears on behalf of the respondent number 2, 3, 4. Mr. S.R. Borua appears for the respondent number 1. Issue notice making it returnable on, we have it after vacation, 24th of July 2023.
My lord.
As the respondent numbers 1 to 4 are duly represented, extra copies of the petition be served upon them by 26th of May 2023. As regards the respondent number 5, steps be taken by way of registered as well as usual by 26/5/2023. The case of the petitioner herein is that the petitioner have not received his salary since 11/5/2017 to till date,
Present day, my lord.
till present. The respondents shall apprise this court The respondents in the education department shall apprise this court as to why the petitioner have not been paid. The respondents in the education department as well as the respondent number 5 shall apprise this court on the next returnable date as to why the petitioner have not been paid the salary since 11/5/2017.
13.
Yes, Mr. Khan.
In this case, my lord, they are agreed by the order passed by the secretary, my lord. That is at page 107. There was an order passed by this honorable court on 5th of March at page 95.
Which is the order of secretary?
That's page 107.
Yes.
So in page 99, my lord, in the previous round, my lord, the honorable court had directed them to look into the matter as to whether there was any administrative lapses. So there is no finding as regards that.
Administrative lapse for what?
For delay in the payment of the pension and pension.
No. First and foremost, the area you are in respect to payment of area
No,
pension with effect from
I'm only in respect of now in payment of the interest part.
interest for which part?
For the delay was because the person retired on 31st of January 2006 and the final pensionary benefit was paid in 2015 after a lapse of nearly 9 years. So that in that regard, my lord, the page 99 may kindly be seen, my lord, paragraph 9. They were to look into as to whether there was any
Then why are you asking for setting aside this order of 10-4?
because this order has rejected the prayer for the payment of interest. At the order,
Where?
if my lord may peruse page 99 of the
No. Where is that order of 10-4? Where does it
107,
say?
my lord.
Huh?
Yeah, 107.
Yes, 107, where the interest has been not given where?
He doesn't mention anything.
Then why you are challenging that order of 10-4
If for area pension and interest on already paid pensionary benefit is not admissible. Page 107.
Pensionary benefits is not admissible is another thing. Your claim is under 197A, isn't it?
Yes, one.
Then,
In payment of
why are you
interest part,
challenging this order of 10-4,
because
making it complicated?
because the interest part has not been paid, my lord.
So interest part is not paid, that is a different thing. But where is the order earlier where it says that the interest has to be paid?
They have to come to a finding, my lord. Page 99 may kindly be seen, my lord.
Yes.
Para 9, my lord. Under the aforesaid circumstances, when there is specific statutory provision dealing with interest in delayed pension, payment of pension, this court is of the opinion that the Commissioner Secretary of Higher Education will be the competent authority as provided under sub-rule 2 of Rule 197 of the 1969 rules to determine as to whether there was any administrative lapses. If there is a finding by the Secretary to the effect that there was administrative lapses for delayed payment of pension, obviously the payment petitioner would be entitled to interest on delayed payment of pension and gratuity. In this regard, it has been submitted by the learned counsel for the petitioner that the petitioner has already submitted representation to the Commissioner Secretary on 2/11/17. Accordingly, the authorities were to consider the said representation submitted by the petitioner on 2/11/17 and will decide whether there was any administrative lapses for the delayed payment of pension and gratuity to the petitioner. And if there is a finding to that effect that the delay in payment of pension and gratuity to the petitioner was caused on account of administrative lapses, the petitioner would be entitled to the interest for the aforesaid delay. So period was
So here he did not decide.
did not disable.
So,
And in the
so it is, you don't need to challenge this order. Anyway, heard Mr. S. Found the learned counsel appearing on behalf of the petitioner. Yes, Mr. What do you have to say?
That's it. Notice may go at least.
Huh?
Notice may go.
Definitely, notice will go.
Yeah.
But this is not a question of notice in a normal notice.
Yes,
It is a case for violating the order of the court. There is a specific direction
Lord.
to look into the question of administrative lapses.
Lord.
By the next date, you are to give me an order to that effect. What is your finding? I don't want all.
Lord.
Mr. A. Tabildar.
A.R. Pahadillar.
A.R. Tabildar appears on behalf of the respondent number 1, 2, and 3. Mr. So-and-so appears for respondent number 4. Issue notice making it returnable by 28th of June. No, earlier than 21st of June, 2023. As the respondent numbers 1 to 5, 1 to 4 are duly represented, extra copies of the petition be served upon them during the course of the day. The case of the petitioner herein is that this court, by the judgment and order dated 5/3/2020 in WPC number 3450/2018, observed that it is the Commissioner and Secretary of the Higher Education Department would be the competent authority as provided under Sub-Rule 2 of Rule 197 of the Assam Service Pension Rules 1969 to determine as to whether there was any administrative lapses. It was further observed that if there is a finding by the Secretary to that effect, that there were administrative lapses for delayed payment of pension, obviously the petitioners would be entitled to interest on delayed payment of pension and gratuity. Further to that, this court passed certain consequences. Further to that, the petitioner, this court directed the respondent number 2 to decide on the question and pass appropriate orders as regards the claim for payment of interest on delayed payment of pension and gratuity in terms with the observations and directions given within a period of 3 months from the date of receipt of the certified copy. Full stop. It further appears from the records that on 18/5/2020, the order passed by this court was served upon the Commissioner and Secretary to the Government of Assam Higher Education Department. Was it?
Yes, my lord.
Not served. Was sent by registered post. That the Commissioner and it further appears that the Commissioner and Secretary to the Government of Assam Higher Education Department was sent a representation on 18/5/2020. Sent a representation dated 18/5/2020 by the registered post on 22/5/2020. The same was repeated by another communication dated 8/9/2020. In pursuance thereto, a speaking order was passed after almost 3 years on 10/4/2023. In the speaking order, which have been challenged in the instant proceedings, there is no reference as regards any considerations so made in terms with the observations made by this court on paragraph number 9 and 11 of its order of the judgment dated 5/3/2020 passed in WPC number 3450/2018. Taking into account the same, the respondent shall apprise this court as to whether there has been a compliance to the order, judgment and order dated so and so, passed in WPC number so and so on the next returnable date, and as to whether there has been any administrative lapses on the part of the respondent authorities entitling the petitioner for delayed payment of interest under Rule 197A of the Assam Assam Service Pension Rules 1969. I think next date something will. 14.
May I please,
Yes.
Lordship, by this application, my lord, I have challenged the impugn order.
Where is that
Transfer
impugn
date
order?
29, my lord.
Hmm?
Page 29, Annexure 6, my lord.
Page 29. Transfer.
Is a transfer, my lord?
My goodness. Transfer. Mr. Roman. I've been sitting on this transfer matters from February onwards. Only 3 transfers given till now. State. Yes.
No, my lord, there is some rules. There is some act, my lord, violation. Complete violation of the state rule.
2020.
Yes.
Yes. Tell me. By this time, I have learned by heart.
Yes, sir.
Yes. Where is it? Hereby transfer. What is this?
This and not, my lord, the language of the order, my lord. is not
Which
transferred.
order you are challenging?
This page 29, Annexure 6.
Page 29.
Yes, ma'am.
In the interest of public service as well as the students' community is hereby asked to provide her service at so with immediate effect. The incumbent will draw her salary.
Yes.
Yes, madam.
Well-
You have circumvented the order.
Lordship, if you read the order, your lordship. the
And why
income-
you are challenging after so long period?
No, my lord, that is not 22, it is 23, my lord.
What?
11/5/23.
Should be 23, your lordship.
How do you know?
Wrongly typed, my lord. This signature of the inspector of the school, that is
23.
23.
11.5. Yes.
Yes,
Tell me how did you do it?
Lordship,
No, you want to transfer as per the act. But how can you do this?
lordship, this is not a transfer.
I
had a
know. This is how you circumvent the provisions of the 2020.
Yes.
Uh,
This is
Lordship,
how you do it. We
Lordship.
see giving you the liberty to take action as per the act.
Lordship, here in the order, it is written in the last line, the incumbent will draw her monthly salary from Morioni Girls High School. Lordship, from there. Here she has been transferred because there is a need of teachers, your lordship, because the enrollment is does not
Okay.
meet the teachers.
We
your
give you
lordship.
7 days. Get your instructions. We
Lordship.
stay till now.
No, that is also not true, my lord. They,
Whether it is true or not, we'll look into it.
yes,
Heard Mr. S. Roman,
Lordship,
the H. Roman.
Lordship, on the next date, the stay may be considered. Your lordship.
No. It has to be given. Where will he go? Tomorrow again, you are going to cause a lot of problems.
Lordship, this is not a transfer order. Only,
Understood.
Lordship.
So it can wait till today is 24th. You get your instructions by next week. No heavens will fall.
Lordship.
You have already allowed him now from 11 to so and so. I'm only asking the status quo to be maintained as of today. That's all. If he has already joined out there, I'm not
no, I have
considering.
not yet done. I have stated.
Heard Mr. H. Roman, the Learning Council, appearing on behalf of the petitioner. Ms. P. Musari appears on behalf of the respondent numbers 1, 2, 4, 5.
4 I am appearing with.
1, 2,
5.
5. 5.
Lordship. 1, 2, and 5.
Mr. D. SR Bull appears for the respondent number 3 and 4.
Four.
Full stop. Issue notice making it returnable on 31st of May. Full stop. As the respondent numbers 1 to 5 are duly represented, extra copies of the writ petition be served during the course of the day. As regards the notice upon the respondent number 6 and 7, the same shall be considered on the next date. The petitioner herein is aggrieved by the order dated 11/5/2023. Bracket wrongly written as 11/5/2022. Bracket close. 22 as the signature in the said order reflects that the inspector of schools signed the said order on 11/5/2023. Bracket close. It is the case of the petitioners that the said order is in gross violation to the provisions of the Assam Elementary and Secondary Schools transfer.
And regulation.
What is the
Regulation
name?
of posting and transfer.
Transfer
Regulation of posting and transfer.
and transfer
Act 2020.
order. Regulation Act 2020,
Yes, my lord. And also, my lord, violates the
which mandates a particular manner in which a teacher could be a teacher in the elementary, secondary education department. Elementary and secondary education department can be transferred. It is the submission of the learned counsel for the petitioner that in order to circumvent the provisions of the Act of 2020, this order has been passed, which is not permissible when a statute duly holds the field. On the other hand, Ms. D. Musari, the learned counsel appearing on behalf of the respondent secondary education department submits that the petitioner have been only temporarily asked to provide the services at this particular school. Without affecting his status as well as his posting. And as such, as the same was done in the administrative exigency, the question of interference with the said order does not arise. However, the learned counsel submits that she would take necessary instructions in that regard, for which a week's time may be granted. Accordingly, on the returnable date, the learned counsel appearing on behalf of the secondary education department shall apprise this court as regards the reasons why this order dated 11/5/2023 was issued by the Inspector of Schools. This court, in the interest of justice, directs the maintenance of status quo in respect to the said order in status quo as regards the posting of the petitioner till the next date.
Obliged, my lord.
15.
This case is, Lordship, for bringing my service under the old pension rules, Lordship, for counting of officiating period, past officiating period, and for altering the date of effect of regularization, Lordship. Lordship, my case is that, Lordship, I was initially appointed, Lordship, following due process of law, Lordship, as laboratory assistant on 25/12/1991. Hereafter, Lordship, my ad hoc appointment was extended time to time, and subsequently it was regularized on, Lordship, 18/6/1994. Then,
Who are you? What is your name?
Lordship,
Binod Chandra Bora.
Das,
Okay.
Lordship, I will go.
You were appointed as
laboratory assistant, Lordship, page 15.
page 15. Is hereby appointed on ad hoc basis.
Ad hoc basis, Lordship.
Then
That ad hoc appointment was regularized, which is at page, Lordship, 20.
20.
20, Lordship.
Yes.
Then, Lordship, the regularization. This is the-
Appointed on ad hoc basis by the mayor is hereby regularized in the post with immediate effect.
Lordship. Then, Lordship, may kindly come to the page number 22. Again, temporarily appointed, Lordship, as this time as LD assistant in continuation to LD.
Yes. Then because he realized that the director SCRT couldn't have regularized you, then that is why I looked into. There is no order of the government. Yes. Then
Lordship, what happened, Lordship? I wrote under the screening committee for regularization. Not only me, Lordship, there are 36 ad hoc employees, Lordship, under the directorate,
then
which is at page 25.
Screening committee. Yes.
Screening committee in the year 2004. Due to non-regularization, Lordship, a group of writ petitions were filed before this court, Lordship.
Where?
Lordship, I will go to that, Lordship, and followed by one interim order, Lordship. Services was regularized, which is at page, Lordship, page 30, Lordship, type copy.
30.
30, Lordship.
In
My name
pursuant
also
to the
shown.
government's letter dated demand, which was concurred by the finance department and in pursuant to the Honorable High Court interim order, the ad hoc services of the following 34 employees, right, with effect from 2000. Under the new pension rules 2005 against the sanction. Yes.
Lordship, I am agreed to that, Lordship. Lordship, to those petitioners will also agree to that findings, Lordship, that is with effect date of regularization and entitlement of pension, Lordship.
And they got orders.
And contended before this court, and accordingly the honorable court disposed of that matter by judgment, Lordship, which is at page, Lordship, 35.
835.
35. Lordship, so far me, Lordship, the relevant.
Therefore, said, wait, while considering the matter, the commission, where is it? Further, the other issue is whether the petitioner will come within the purview of so and so act. Under the Assam, if the petitioner meets the requirement of the last qualifying service, they are entitled to regular pension as provided. Whereas as per the new pension scheme, when while considering the matter, the director would refer the matter to the commissioner to take a decision and pass an appropriate order as to whether in such cases where the order of regularization has been passed from a date of subsequent to the month, but the effect is given from a date prior to it, as to whether such category of it. Suppose the exercise of arriving at the conclusion that it so this court did not give.
Lordship,
Directed them to consider.
Lordship, I'm going to that, Lordship. Lordship, followed by that judgment, Lordship, so no common order are passed, Lordship. Individual or benefits have been given to the similarly situated person. I have annexed one or two of them, Lordship. One is at page 51. 51. 51.
Then?
And 52 also, Lord. Similarly situated person.
What is 53?
51, 52. 53 is a OM, Lordship. And
OM for what?
For counting of officiating period, Lordship. And for
This is for the central government.
but state government also come under that office memorandum as
Where?
per paragraph number 3.
Where? It doesn't say anything. Yes, Mr. Barbuzari, the government has done all these things. Why not the benefit should be given?
First of all, my lord, the petitioner appears to be a fence sitter.
Whatever may be, fence sitter or non-fence sitter, but there was no direction of this court to give. The direction of the court was only is for consideration. And your authorities have taken, then it is now the decision of the government. You see, the government has done it. Joint Secretary to Government, Elementary Education Department. Page 51.
51 is almost, my lord, illegible, my lord. Lordship will kindly say 52.
If you have problem, let me read it.
So, I'll read it. Sir.
I'll read it.
I'll read it.
In inviting a reference to your letter on the I am directed to convey no objection of the government in the elementary education towards the proposal regarding regularization of the ad hoc service period and counting of the past service for the purpose of computation of pensionary benefits only and allowing pension and other retirement benefits under the Assam service area to so and so in compliance with the order dated so and so. Meaning thereby they have given effect to 31. Why same should not be given to them?
After, because in Purnima holiday decision, my lord has dealt with this issue.
No, I have not dealt with ad hoc.
Ad hoc is there.
No ad hoc. No ad hoc business. Where is the ad hoc? You are having Purnima holiday stipendary.
Stipendary?
That is not there. Number 2 comes as regards drop. They were never there. Number 3 comes excess. That is illegal. Number 4 comes OBB. That is different. Number 5 comes as regards the the Dimahasa. That is not there.
And one another category was, my lord, teachers appointed under ad hoc grant.
That is no grant,
Grant.
and there is rule 5, section 5(1) and 5(2) of the 2011 Act. And therefore they were getting the benefit, and section 24 gives them the benefit.
Now, here is a case, my lord, where
Here what they have done, they have done it. Then why should why if you have not acted upon this,
Yeah.
then this has the approval of the finance budget. See, down below. Then why he shouldn't be getting the benefit?
Lord, sir, maybe please to issue notice that. Because it is this order is dated 2013, which is put to challenge here. He has waited for so many long time.
Court dispose of that matter in the year 2018.
Therefore, I have made that opening submission that he is a fence sitter.
No. Fence sitter, non-fence sitter, then why he shouldn't be getting that benefit? Fence sitter aspect wouldn't come out here.
No, there is no explanation in the writ petition, my lord, what he was doing post 2013. This impugn order was, my lord, issued on 4th September 2013.
Which one?
It is now, my lord, 10 years down the line.
4th September 2013 is which one?
My lord, Annexure K at page 30, which is put to challenge hearing.
So that order, that
Okay,
regulation
page 13. Page?
Page 30. Page 30 is the type copy. In my,
What is this order?
this is the, my lord, order whereby, my lord, they have been brought within the ambit of the new pension rules.
Understood. They were brought out there. So
They were-
of these people,
Of this,
some have approached.
Some of that-
Who are those people who have approached?
that's it.
No, I would have understood. Are these any of these people out here? Mukundo Rava.
That's it. Yes,
Where is that Mukundo Rava?
Lordship. Mukunda Rabba is there, Lordship. Petitioner number 3, Lordship.
No,
30,
petitioner number
30.
3 here at page 35. But
Page
who is
35.
Mukundo
In
Deka?
regularization order, Lordship, may I have categorically stated in my petition, Lordship, paragraph number 9.
Where you are
Lordship.
part of the WPC number
No,
434.
Lordship. I am not a part of that petition. Lordship.
Okay. Then why your name was inserted?
Lordship, they were the similar report. There are 36 numbers of employees. Another director.
Hello, we'll take it up at 2. As it is a dispute, reference to arbitration, I am going to make. He need not go and file his within 3 months. And he will dispose of as per, because as per 3G5, it says that it will be done as per the Arbitration and Conciliation Act. So he'll do it. Now, the divisional commissioner at that point of time for Barak Valley has his seat out there in Dispur. Now he has it in Kasar.
No, my lord, just now I got information.
Yeah.
I was also not running. Earlier, there is a 3 division, Central, Tezpur, and Barak Valley, and our Guwahati.
Right.
Division. Now I have heard that notification is out because this as cases are, I think because of less cases, now Lower Assam Commissioner is looking after this, all cases. That is also I have to be not sure. Television is out.
So whom should I send it?
That is right now, Lordship. Today I'll find out. Today
Will let me know tomorrow.
Tomorrow I'll get it.
Huh? I am yet to
If I
sign.
get the notification,
Hmm.
that will be better for you.
Yes, if you
Because
just
one case, what happened, my lord, like this, our honorable quoted first and directed that it has gone to Silchar. That there is a retrospect that no, it is office is not there.
But there is a
Court
but today I could check it out from the Guwahati, from the state of Assam's website. It is there. They have a divisional commissioner at Barak Valley.
Yes.
One Nina Neeraj Gupta or something to that effect. She is there. So wouldn't that come within that ambit?
No, that's correct, my lord. That is there. But one notification has recently been out. I have heard in other cases that all these arbitration cases, NSS case will be now all divisions will be looked into by Lower Assam Commissioner.
Okay,
That
you
is, I have-
get hold of that.
Today
notification.
I'll try to take out that notification. Tomorrow morning I'll get it. Whatever.
Kindly inform your counterpart,
Oh, yes.
Mr. Nath, because he is not here, that it is not
No,
required
I'll
for
inform
them.
him. I'll inform. Tomorrow we'll come together.
Yes.
My oblige.
15.
Mr. Babujari.
So this is 2013 impugn, which he has impugned here and he has challenged it after, my lord, almost 10 years. That is one aspect of the matter. There is no explanation in the writ petition as such. At this case, Lordship may issue notice, and if the order which he is relying upon, there, although this honorable court has not specifically mandated, not issued mandamus per se in the positive sense.
Not per se, no mandamus was issued.
Yes.
There was a direction for consideration.
But nonetheless,
But you
my
have
lord,
done it,
yes,
and the
nonetheless,
finance, your department have readily approved.
yes, approved it.
And
Now,
I
whether-
think they have done it in terms with that judgment of direct recruit 43 paragraph of 41, wherein it says that once you confirm an ad hoc, the earlier period of service has to be taken into account.
But there are apex court decisions which says, my lord, that earlier period cannot be taken.
No,
in-
no, if you are not in government service, it's a different thing.
Yes.
But if you are in government service, then
No, government service, everybody is, my lord, working for the government, but in the capacity, in ad hoc capacity. So therefore, my lord, that services cannot be counted. So
how do you say so? Then what do you say about the notification of giving it to the master roll workers?
the notification, it is there. master order.
Then
Ad
you
hoc-
have on your own, you keep on doing all these things. Then you are opposing it. No, no.
Lordship may be pleased to issue notice here.
Yes, I have issued
Because
notice.
here I am not the administrative department.
Then, Mr. M, but it has been at the finance approval readily,
No, my lord, I
happily.
am going by the record, my lord, record says I cannot.
Heard Mr. M. Deka?
It's still of the law.
H. Talukdar, the learned counsel appearing on behalf of the petitioner, Mr. Who appears for elementary?
My lord,
You are appearing for elementary.
Yes, sir. A Fukan.
A. Pukan appears for respond number 1. Who appears for SCRT? Mr. S1 and Mr. S. Bora appears for respond number 2. And who about 5?
I am for 4.
5.
Principal District Training Institute, Pune. Pune.
Lordship, under the SCRT, he is under the
SCRT. So for 2 and 5, Mr. Arbo Pujari appears for respond number 5. 3,
my lord.
Mr. S.R. Borua. Oh, you are. Ms. S. Borua appears on behalf of the respondent number 4. Issue notice making it returnable on 26th of July 2023. As the respondents are duly represented, extra copies of the writ petition be served by 26th of May 2023. The case of the petitioner herein is that the petitioner was initially appointed by the director SCRT on 25th of December 1991. As on ad hoc basis as laboratory assistant. The said period of service, the appointment of the petitioner was continued from time to time. Subsequent thereto, on 18/6/1994, an order was passed by the director SCRT that the service of the petitioner was regularized. Be that as it may, the petitioner was again appointed temporarily as LDA cum typist on 31/31/1996. The petitioner continued to render his service and by an order dated 4th of September 2013, the services of the petitioner was regularized with effect from 27/3/2007 under the new pension rules of 2005 against sanctioned vacant posts. It is the case of the petitioner that similarly situated persons have approached this court challenging that they should come within the ambit of the old pension scheme in terms with the Assam Service Pension Rules 1969 in WPC number 476/2013, as well as other similar matters. This court, by an order dated 29/5/2017, after taking note of the contention so raised, directed the director, SCRT, to take a call as to whether similarly situated persons, as to whether the petitioners in the said writ petitions would come within the ambit of the old pension scheme in terms with the Assam Service Pension Rules 1969. Subsequent thereto, on 2nd of August 2022, the Joint Secretary to the Government of Assam Elementary Education Department issued a communication to the Director of SCRT, that is the respondent number 2, stating inter alia that those persons who were petitioners in WPC number 63/2013 and WPC number 434/2013 would be entitled to, in terms with the Assam Service Pension Rules 1969, as the government in the Elementary Education Department had no objection in regularizing their ad hoc service period and counting of the past service for the purpose of computation of the pensionary benefits only, and allowing pension and other retirement benefits under the Assam Service Pension Rules 1969. It is further seen from the order dated from the communication dated 2/8/2022 issued by the Joint Secretary to the Government of Assam Elementary Education Department that the said proposal had the approval of the Finance Budget Department. The petitioner herein has approached this court seeking similar treatment as has been given to other similarly situated persons. The respondents are directed to file their affidavits on or before 19th of July 2023, stating inter alia as to whether the petitioner herein would be entitled to the similar benefits as have been given to similarly situated persons.
Obliged, Lordship. I have a small query, my lord. My name may be reflected, my lord. SCRT has not given the copy we served as well as the name we reflected in the release.
এইটো কোৱা নাই নহয় এক্সট্ৰা কপিজ দিব লাগিব বুলি সেইটো লিখি দিব এইটো পাহৰিব পাৰো as all the respondents are duly represented, extra copies of the petition be served by 26th of May. I've said that.
My SCRT has not been reflected in the cause list.
The registry shall show the name of Mr. S. Bora, appear standing counsel for the NCR, SCR.
Obliged, Lordship.
16.
Yes, Mr. Sharma.
My lord, in this petition, my lord, we have assigned that, my lord, two order, my lord, that, my lord, order dated 24th of 10.
Tertiary should not be issued to set aside the year whereby the petitioner has been placed under suspension. Tertiary should not be issued to set aside the impugned show cause notice and reinstate the petitioner. Mandamus should not be directing the impugned organ be kept in aware. Yes, why? What is the problem?
My lord, in pursuant to an FIR, my lord, filed by the commissioner of GMC, my lord, the petitioner was arrested on 21st of October, my lord. And my lord, consequently, my lord, on 24th October, my lord, he was placed under suspension. That is the F case 44, my lord. So, my lord, not literally it was written, my lord, indicated, but my lord, that suspension order was issued, my lord, as per my lord, Rule 6, subsection 2 of the Assam Discipline and Appeal Rules, my lord. And subsequently, my lord, so-called notice was issued on 29th of October, December 2022, my lord. And in the meantime, my lord, on 11th of January, my lord, 2023, the charge sheet is also filed, my lord, in the criminal case, my lord. So, my lord,
Where upon receipt of the demand regarding the arrest of so-and-so, man of Guwahati Municipal Corporation and pending trial of the demand, following engineers are hereby placed under suspension with effect from 24th of October 2022. Yes, then you got bail.
Yes, it's already granted bail, my lord. So, my
You
lord,
got bail on 19/12/2022.
yes, my lord.
Okay, then
My lord, charge sheet has already been filed by that.
no, memorandum of charge has been given to you on 29/12/2022.
Then, my lord, we have submitted our reply also, my lord.
Then
on 6/1, my lord. Then, my lord.
Then what do you mean?
Then, my lord, on Annexure J, page 61, my lord, that we have submitted another representation for the revocation of the suspension order, my lord.
Why?
So, my lord, because, my lord, already 3 months has already elapsed, my lord.
For what?
From the date of suspension, my lord.
But you have been given the memorandum of charge.
Yes, my lord. But
Then,
my lord, as my lord has been rendered in my lord Ajoy Chaudhary case, my lord. As per my information, my lord, till now, my lord, no review, no extension was issued, my lord. But, so, my lord, Ajoy Chaudhary, as per rendered in the Ajoy Chaudhary judgment, my lord, the respondent authority.
no, you were given the charge sheet on when?
29/12. Yes, my lord.
And if you see, the Ajoy Chaudhary does not say that the extension has to be within a particular period.
Yes, my lord. But, my lord, that regarding my lord extension, my lord, after 3 months, if charge sheet has been filed, my lord, then also, my lord, one region order should be there, my lord.
Why?
Yes, my lord.
They will give it. Do they give a reason?
My lord, till that, my lord, no such order has been passed, my lord.
I will get the instruction, Lord.
Give a reason order. Matter over.
And secondly, my lord, as per my lord, Ample Anthony's case, my lord. So, my lord, where it is specifically stated that, my lord, where it has been held that if the departmental proceeding and the criminal cases are based on identical and similar set of facts and served in the criminal case against the delinquent employee, it of a great nature, which involves complicated question of law and fact, it is desirable to stay the departmental proceeding till conclusion of criminal case. In same case, my lord, that
So you want the departmental proceedings to be stayed,
stayed, my lord.
and you want to remain in suspension.
No, my lord.
Then?
My lord, I have both of my lord, my prayer is there, my lord.
Present Lordship will issue notice, my lord.
And my lord,
Notice. You are helping the petitioner. This is not a case of notice.
So I will, otherwise I will get the instruction, my lord.
Huh?
I will get the instruction.
No.
Region
Why
order.
notice? He will direct you to the whatever maybe do it, because there is a particular office memorandum dated 4/2/2020, isn't it? Of the chief secretary, wherein it says within 6 months you have to review. And the suspension was given on, the office memorandum was given on 24/12/2022. 6 months will have elapsed on 24. Do whatever review you have to do it. Nothing remains. You dispose it of.
and my lord, just one thing that under 6.2 also, my lord, rule 6.2 also.
6.2?
As per rule 6.2 of the discipline.
But what do you say about 6.1?
No, my lord.
No, what do you say about 6.1? The departmental proceedings have already been initiated. So under such, they can keep you
Yes.
under suspension.
Yes.
So they can very well do it. And in fact, in a recent judgment of the division bench, he has stated, the division bench has categorically stated that the horse 6-2, a person may be entitled to reinstatement, but 6-1 can still be exercised for putting somebody under suspension.
Lordship,
You exercise that
Lordship,
power,
Lordship, Lordship.
but if you don't exercise it within the 6 months, then you are to reinstate it.
Lordship, as per that memorandum, office memorandum will.
Heard Mr. A.K. Sharma, the learned senior counsel, assisted learned counsel appearing on behalf of the petitioner. Mr.
No, I appear
S.
for.
Bora appears on behalf of the respondent number 1. You,
Also, I am for 2.
Ms. M. D. Bora appears for the respondent number 2. The petitioner herein have challenged the order of suspension dated 24/10/2022, as well as also the departmental proceedings initiated on the basis of the memorandum of charge dated 29/12/2022. Taking into account the issue involved, the incident matter is taken up for disposal at the motion stage itself. I'll be next. It is the contention of the petitioner that the order dated 24/10/2022, whereby the petitioner was put under suspension, but in view of the law laid down by the Supreme Court in the case of Ajoy Kumar Chaudhary versus Union of India reported in so and so, and more particularly paragraph number 21, wherein it has been mentioned that even after the memorandum of charge have been served upon the delinquent employee, the respondent authorities, the disciplinary authority has to pass an order, reasoned order, for extending the suspension period, which have not been done in the instant case. And as such, the petitioner is entitled to reinstatement. It is the further submission of the petitioner that the instant disciplinary proceedings should be quashed. You are asking for quashing.
Yes, sir. Yes, sir.
Quash.
Suspension or quash?
On the ground that there is a criminal proceedings pending before the criminal courts. On the other hand, Mr. S. Bora, the learned counsel appearing on behalf of the GMC submits that though in the judgment of the Supreme Court in the case of Ajoy Kumar Chaudhary, a direction has been given. No, don't really, what? That in the judgment of the Supreme Court in the case of Ajoy Kumar Chaudhary, a direction has been given upon furnishing or upon serving the memorandum of charge to upon the delinquent employee, a reasoned order has to be passed to the for extending the suspension period. The learned counsel referred to the office memorandum dated 4/2/2020 issued by the Chief Secretary of the government of Assam in the personnel department, wherein it has been mentioned that a review has to be made within a period of 6 months from the date of submission serving the memorandum of charge. The Learned Counsel, appearing on behalf of the respondent number 1, further submitted that the memorandum of charge was served upon the petitioner on 24/12/2022, 29/12/2022, and as on date, the period of 6 months is not over. Be that as it may, it is the further submission of the Learned Counsel for the respondent number 1 that in compliance to the office memorandum dated 4/2/2020, as well as the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary, steps would be taken within how much time? 15 days?
What's it, 15 days? 15 days.
Within 15 days from today, if such steps have not yet been taken. On the question, on the submission as regards quashing of the disciplinary proceedings on the basis that there is a criminal proceedings having been initiated, the Learned Counsel, appearing for the respondent number 1, submits that the same is contrary to the well-settled principles of law, taking into account that the criminal proceedings, that the departmental proceedings can very well continue side by side with the criminal proceedings. And it is only in extreme cases where the criminal proceedings relates to charges of grave nature, the departmental proceedings can at best be stayed, not quashed. Upon hearing the Learned Counsels for the parties, and taking into account that the memorandum of charge was issued on 29/12/2022, and the petitioner have also submitted a reply on 6/1/2023, and the disciplinary proceedings is presently going ahead, this court does not find any justifiable ground for interference with the suspension order However, it is made clear that it is the mandate of law that there has to be extension of the suspension order by a reasoned order, which, as per the office memorandum dated 4/2/2020, is to be done within a period of 6 months. Taking into account that the Learned Counsel, appearing on behalf of the petitioner, the respondent number 1, submits that the same would be done within a period of 15 days from today. This court is not inclined to interfere with the order of suspension or the further continuation of the suspension. Subject to the respondent authorities passing a reasoned order within 15 days from the date of the instant order. Next, in respect to the question pertaining to quashing of the disciplinary proceedings on the ground that there is a criminal proceedings initiated, it is no longer res integra that a criminal proceedings as well as the disciplinary proceedings can run side by side. And it is only in the case of grave nature, case of offenses of grave nature, the disciplinary proceedings can be stayed. Pending disposal of the criminal proceedings. Under such circumstances, the question of interfering with the disciplinary proceedings does not arise in the facts and circumstances of the instant case. Accordingly, the instant petition therefore stands disposed of in terms with the observations made herein above.
So item number 17, 18, and 19, they are similar, but 17, the date of that is charge date is different. Exactly identical. Charge the date is 26/12. So it's not
Date of
getting into it.
suspension on 22nd of 11.
I look, make a disposal. I'll dispose. That कोई उठे का बेलेग के कोई 20. Yes, Mr. Kaushik.
The petitioner was initially appointed under a scheme of NRHM in the year 2010. Though, my lord, he, as pursuant to the appointment, my lord, he has joined.
Absorb the petitioner permanently as a computer assistant in the office of the month and to pay his earlier salary with effect from 22. How does this for direct absorption?
My lord, the petitioner, my lord, initially when he was appointed under a scheme of the NRHM, my lord, he joined his place of posting, but the deputy commissioner retained him and did not allow him to join, saying to the NRHM that he is working in some computer project in the deputy commissioner. And thereafter, they continued him working under the deputy commissioner. Now, there was a office memorandum of the NRHM which gave the job security to all these contractual nature who were appointed by them. Well, this petitioner has lost that opportunity because of the reason because deputy commissioner never released it. In fact,
Deputy commissioner, that person or the office?
Malodi,
That person or the office?
the deputy commissioner, the office of the deputy commissioner. And Malodi, deputy commissioner indicated to the NRHM that we cannot release him because he's working some in some computer related works in the department. And thereafter he was posted in the sub-register office. He continued. The sub-register office has acknowledged his service since 2011, my lord. And since July 2022, he has not been paid his salary. And till July 22, he has been paid his salary regularly also.
Yes, madam.
Instruction required, Lordship, but he does not annex the engagement order by the deputy commissioner, the appointment order of the deputy commissioner office. Lordship.
Why you have not done that?
But that appointment order is not there. Well, Lordship will find page 27, the joining report, which has been acknowledged by the sub-register of the Kamrup.
So why haven't you enclosed the appointment order?
Well, the initial appointment order is page 21 under the NRHM.
We are not concerned with NRHM. You want the confirmation in the post of so and so. You are asking for your salary, area salary, unless you have some source. How do I bring?
Page 24 for a moment. This is the communication of the additional deputy commissioner to the superintendent of Kamrup district hospital.
The computer assistant in your hospital. He is working some important computer work in this office. So his service will be required for some days.
Then
not always.
Then your lordship will again find page 26.
He will be spared after completion of the work. Then
page 26.
25. In the interest of so and so, is appointed as a computer assistant for last year's.
The remuneration was fixed by the NRHM, and he was paid the remuneration by the NRHM at that point of time, though he was serving in the office of the deputy commissioner.
Then
page 26, again the deputy commissioner in 8/12/2022. Page 26.
Who is an employee of your hospital, your work has been working in the land record committee in the office, regularly attending the office from so and so to so. From July to November.
Yes.
Then
Your lordship will find the acknowledgement of the sub-register at page 41, who confirms, my lord, I have been working since 26/11/2020.
Hmm.
Page 41.
so you say that you have missed out this thing on 20, which is being given on 26th of February 2021.
My lord.
You want this engagement till 60 years.
My lord.
And you will be entitled to what? You shall not be thrown out.
My lord.
Then casual leave, child care leave, bank loan,
Everything has been given to
gratuity.
those contractually.
In line of department may redeploy NHM to other institutions. This is NHM.
NHM.
And what is this NHRM?
National
Rural Health Mission. This is under the national. Where is the NHM? Yes.
Earlier it is called NRHM, National Rural Health Mission.
Now NHM. So,
and my service, my lord, since 2011 is not disputed by the authorities, my lord. In fact, my lord, page 42. Your
so why
lordship-
you are not asking for getting the same benefits which are there?
My lord.
Why you are not asking that you should be given the same benefits in terms with the NHM there?
My lord, because this office memorandum, there is one condition, my lord, that I have to continue as a contractual employee under the NRHM.
Understood, but you you were all along paid by the NHM.
No, initially I was paid by the NRHM.
Then
And subsequently, when I was retained by the office of the sub-registrar, my lord, I have been paid by the sub-registrar. And my remunerations were fixed by the sub-registrar office. The lordship will find page 33 onwards, my lord. There are series of orders, my lord, whereby my remunerations were fixed by the district registrar. And the same district registrar on page 42 again issued an order to me, engaging me on contractual for a period of 11 months.
Where?
Page 42.
40?
42.
Hereby engaged on contract under the executive for 11 months on the date of joining to perform the job computer after execution of the student. Yes, then
Still, I'm continuing, my lord, though this order expires on 24/1/2021.
22.
My lord, it's 20.
24
20.
1 2022. Then
I have been paid till July 2022.
why?
Since July 2022, I have not been paid.
Understood. How did you get money thereafter?
Because my services are being utilized by them. Even today, they are utilized by them.
Without an extension of this.
Nothing. But
So
in
then
fact,
how,
my lord,
as of now, there is no extension. How can this
My lord,
court serve you?
my lord, this order, though this order says, my lord, contractual loan, I have never been asked to sign any contract, my lord. The appointment was shown as a contractual.
But did you accept it?
My lord,
Did you not work out there on the basis of this order?
my lord, I was already working in that office.
Very good. You have been working out there, but then
Since
also you
2011, I
continue.
have been working, my lord. in
No,
that
how
office.
can this court direct regularization?
But at this stage, my lord, I'm praying for the current salary, my lord, because they have been utilizing.
How
my-
can I give the direction as of now when you have no contract?
My lord, even this order has not been extended, but pursuant after that also, my lord, until June, they have paid me. I made a categorical statement, my lord.
And then when is your representation for making payment thereafter?
Representations I have not paid.
Then
Your
why do you
lordship will
come
find
to the
case-
court directly?
My lord, lordship will find case.
If you are on the other side, you will come up with this type of pleas, which you normally do. Then now you have not done it. I still remember that day you had said, where is the representation? Then now you can say, tell me, you have not submitted a representation. Why you are before this court? after 1 year. At least that was required. That you have not got your salary, there must be something. Otherwise, why haven't you submitted a representation? And you have now come directly. They're not even asking for anything, directly the moon of getting regularization. At least I'll get my salary. If I won't get the moon, it's something like that.
Malad, my service, utilization of service, they will not dispute.
But Mr. Kaushik, you were appointed in the NRHM also as a contractor. That was every period of 11 months. Those contracts have been signed by you, I suppose. Now you have stopped signing.
Yes.
You have stopped signing it.
No, in the NRHM, Malad, when I was appointed, I signed the contract. I joined the duty.
For 11 months.
Malad.
That contract ended. And thereafter, there has been various contracts entered into. You are no longer there.
No, yes. Because NRHM, I could not continue in NRHM because of the deputy commissioner's letter, Malad. They did not release me, Malad.
This is a case of issuing just a notice, nothing more than, without writing anything further. Writing something further would be disastrous. Heard Mr. B. Kaushik, I won't dismiss it right away. Because the authorities may be considerate. Heard Mr. B. Kaushik, the learned counsel appearing on behalf of the petitioner, Ms. S. Borua, appears on behalf of the respondent number
4 and 5.
4 and 5.
For 2 and 3.
Mr. S. Dotto appears for the respondent number 1. Ms. S. Bora. A. Bora appears for respondent number 2 and 3. And Ms. S. Borua appears for respondent number 4 and 5. Issue notice making it returnable on 26th of July 2023. As the respondents are duly represented, extra copies of the petition be served upon them by 26th of May 2023. The case of the petitioner herein is that the petitioner was initially engaged by the respondent number 2 and 3 on contractual basis. However, as the petitioner was rendering service in the office of the respondent number 4 and 5, the petitioner could not join the services in under the respondent number 2. Initially, the respondent number 2 was disbursing the salary to the petitioner, but subsequently, the salary of the petitioner was fixed from time to time by the senior sub-register Sadar Amingao. That is the respondent number 5. It further appears on record that on 24/2/2021, the district register Kamrup Amingao had issued an order for contractual engagement of the petitioner for a period of 11 months. And the said period ended on 24/1/2022. However, the petitioner still continues in service in the office. However, it is the case of the petitioner that he still continues in service in the office of the sub-register Kamingao. But he have not been paid his salary since July 2022. July.
Till June they have paid.
June.
Till June they have paid me.
From July you are not. The petitioner is therefore before this court for a direction that the petitioner's services be regularized in the office of the sub-register, Kamrup, Amingang. And also to pay him the area salary from the month of July till date, and also for continuation of his service, salary, payment of the salary till he is regularly absorbed. The respondents are directed to obtain the instructions as to whether the petitioner would be entitled to the claim as well.
But may I claim a tendency of the
No, that is too much. If their pendency is there, withdraw the petition, go there. You know, you will get better orders there. This order will be more disastrous. Yes.
21, order no steps.
Yes. Have you taken steps?
We have taken steps.
The Learned Council, Mr.
R.A. Chaudhary.
R.A.
Chaudhary.
R.A. Chaudhary submits that he has already taken steps today. So accordingly, the registry shall verify the same and list the matter accordingly. And accordingly, the registry shall verify and list the matter.
Lordship, one small prayer. Lordship, I am appearing on behalf of Assam Plain Tribes Development Corporation.
Oh.
Name is not reflected. Assam Plain Tribes Development Corporation Limited. Lordship, SCAPDTC is not reflected in the cause list. Lordship, it may be reflected.
Wait. We have got hold of a SC of this place. We don't get it. They never appear in the courts.
Lordship.
This is for payment.
Lordship.
Lordship, similar matter is fixed on 29th of May.
Yes. You have taken steps
Lordship today.
against?
Against all the respondents.
You have not taken steps with 1, 2, and 3.
Copies were served, my lord.
You have served the copy.
Served, your lordship.
You have got the copy.
Lordship, yes. I am appearing on behalf of respondent number 4.
Okay. So and so, third Mr.
R.A. Chaudhary.
So and so, the Learned Counsel for the petitioner. Your name?
G. Swami.
G. Swami appears for the respondent number 4. Mr. R. Babuzari appears for the respondent number 2. And is Mr. R. Dhar anywhere in the vicinity of the High Court? Mr. R. Dhar appears for the respondent number 1 and 3. The Learned Counsel for the petitioner submits that he has duly taken the steps. It has been brought to the attention of this court by the Learned Counsel, Ms. G. Swami, that similar matters are fixed on 29/5/2023 before this court, which is before this court. So, accordingly, let this matter be listed on 29/5/2023 along with WPC number
5636 of 2016.
16. The name of Ms. G. Swami be shown as the standing counsel of the what is that?
Lordship, A. Sharma. A. Sharma name be shown. Or else SCAPDTC.
Name of
APTDC.
Be shown in the cause list.
Obliged.
And number 28.
Yes, you don't appear when the matter is called. Why?
Sorry, my lord.
Why put your name in that earlier matter?
Yes, because the last occasion I could not appear.
Excess drawal
Lordship.
for overstay.
Lordship, for wrong fixation of the.
So wouldn't it be covered
It will be
under
covered,
Rafiq Masih?
Lordship.
We would make it covered and then pass the order for doing the needful.
Lordship.
Then only he will get it. Otherwise, they will spend the
Lordship.
months and months.
Lordship.
We dispose it of
Lordship.
allowing your petition. Heard. Now, instead of non-appears, what should I put your name? A. Rahman, the learned counsel for the petitioner, Ms. D. Musahari, appears on behalf of the respondent secondary education department. Yes, madam, your name. Ms. So appears on behalf of the accountant general AE, and Mr. S.R. Borua appears for the director of pensions
2 and 5.
2 and 5. The case of the petitioner herein is that the petitioner retired on in the year 2014. However, have you got your provisional pension?
My family pension has not been fixed yet, my lord.
Family pension? What is this family pension business?
My pension has not been fixed yet.
Then
Lordship is getting his provisional pension, and DCRG and other retirement benefits have been given. Your Lordship.
Had retired in the year 2014. Full stop. Subsequent thereto, the petitioner have been receiving the provisional pension, comma, DCRG have already received the provisional pension. And however, subsequent thereto, the petitioner have received the DCRG, provisional DCRG, na?
Lordship.
Provisional DCRG, comma, and presently is getting the provisional pension. However, the final pension of the petitioner have not been finalized, and it is under such circumstances that the petitioner is before this court. This court, by an order dated 19/10/2020, had issued notice, and in the you should notice, and further in the interim directed the respondents not to recover the excess amount of rupees 1,62,289 from the pensionary benefits of the petitioner if the same has not yet been recovered. It is further apparent from a perusal of the records that the excess amount of rupees 1,62,289 is on account of wrong fixation of the salary of the petitioner. It has been stated in the writ petition and also submitted by the learned counsel for the petitioner that the fixation of the pay in respect to the fixation of the pay of the petitioner had no role. Today, when the matter has been listed, Ms. D. Musahari, the learned standing counsel for the secondary education department, has placed on record an instruction issued, a communication issued by the Inspector of Schools, Dhubri, to the Director of Secondary Education, Assam, whereby a request was made for taking necessary steps in terms with the government OM dated 27/1/2022 for waiving, isn't that for waiving? No?
Lordship.
For waiving the excess drawn amount and finalize the pension in respect of the petitioner, as he had retired on 30/6/2014 until that his pension have not been finalized due to wrong fixation and pay, etc. The said instruction is kept on record and marked with the letter Y. The law as regards recovery from retired employees on account of wrong fixation of pay is well settled by the judgments of the Supreme Court. Full stop. The judgment of the Supreme Court in the case of state of, what is that?
State of Punjab.
State of Punjab versus Rafiq Masih, whitewasher, reported in so and so, categorically mandates the circumstances under which mandates the circumstances in paragraph number 18 when such recovery shall not be permissible. So paragraph number 18 of the said judgment is reproduced hereunder. The case of the petitioner is squarely covered by the directions of the Supreme Court in the case of squarely covered by the directions in paragraph number 18(2) of the aforesaid judgment. And as such, the recovery of the said amount of rupees 1,62,289 from the pensionary benefits of the petitioner would be impermissible. In that view of the matter, this court therefore disposes of the incident with petition, directing the Director of Pension, who is going to finalize.
Director of Pension will finalize after receive the fresh proposal and
Directing the Director of Secondary Education, Assam, as well as the Director of Pension, to take appropriate steps for finalizing the pension of the petitioner within 4 months from the date a certified copy of the incident order is served to the Director of Pension as well as the Director of Secondary Education.
pension will be finalized at the correct scale of pay. After
It is made clear that while finalizing the pension papers and while submission that the Director of Secondary Education shall, while sending the proposal to the Director of Pension, shall send a proposal on the basis of the correct scale of pay. Produce that register.
Yes, Lordship, all the
Then-
registers, Lordship. Her name was not there, Lordship, and Lordship may have a look at the order dated 20/2023, Lordship. There in the last paragraph, Lordship, the learned counsel for the petitioner is further directed to apprise this court on the next date as regards to the authenticity of the annexure A to the affidavit in reply filed by the petitioner on 21/7/2022, Lordship. Cheers,
So he has filed an additional affidavit on 5/12/0. You have got it, Mr. Counsel?
My lord, I have annexed, my lord, but my lord, he stated.
Authenticity of annexure A to the affidavit in reply.
Lordship, those registers were produced, Lordship, before you.
Yes, authenticity of this document annexure A. What is the authenticity?
My lord, she has, my lord, collected from, my lord, photocopy has been collected.
So you have to put it by way of an affidavit regarding this, by way of an affidavit. Further, I apprise this court on the next
Lordship,
date.
kindly see, my lord, annexer D, my lord, their affidavit is running page 42, my lord.
Annexer?
Annexer D, page 42, running page 42.
42.
My lord, from this, my lord, letter, my lord, I was in service up to 2017, my lord. My service has not been terminated. No, my lord, disciplinary proceeding against me initiated.
From 2017.
17, my lord.
Thereafter?
Thereafter, my lord, as per instruction, my lord, I am in job, my lord. I am doing, my lord, discharging my job, my lord. My lord, in my additional affidavit, I have specifically stated, my lord, after getting
No, whatever may be, but what is this authenticity of Annexure A?
Lordship, that is the, Lordship, that.
What is this register? Has no sign, nothing.
My lord, nothing.
How are you enclosing these type of documents?
These are all manufactured,
It is very serious. Are you aware, Mr. Counsel?
My lord, in my additional affidavit, I have stated, my lord, after getting notice from this honorable court, my lord, register and other, my lord, employee in the may I help unit, my lord, transferred, my lord. I am in job, my lord.
Lordship, Lordship, let me
I am
file my
not allowed
additional
to put my
affidavit, Lordship.
signature
I'll
on
bring
the
everything on
agency
record.
register.
But you have failed to do so.
Lordship, last chance, Lordship, 2 weeks.
Last chance? What last chance? 2 weeks. No 2 weeks business.
My lord, your lordship, kindly see.
This
their
is
affidavit.
subject to today's here. I can give you till Monday. At best. 29th.
Can it be on 30th, Lord?
No.
29th?
29th.
29th.
29th, you have to file the affidavit. The matter comes on 31st. If not, we will assume that he is in service.
Public.
Heard Mr.
A. Manna.
A. Mananda, the learned counsel appearing on behalf of the petitioner. Mr. D. Upamanyu, the learned counsel appearing on behalf of the health department. This court on 27/2/2023 have directed the health department to file an affidavit, additional affidavit, detailing the reasons why the petitioner had not been paid the salary as well as the status of the petitioner in the department. The said writ petition was directed to be listed on 29/3/2023 thereafter. Almost 3 months have passed by, but no such additional affidavit has been filed by the health department. Today, the learned counsel appearing for the health department seeks for a further accommodation. Taking into account the case of the petitioner and the grievance is so raised, and the case of the petitioner, the grievance is so raised, and the fact that the health department has not filed the affidavit till date, even after a period of almost 3 months have elapsed. This court fixes the matter again on 31st of May 2023. The said affidavit, additional affidavit, has to be filed by the health department by 29th of May 2023.
Submission before you lost it, my lord. My lord, I am in apprehension, my lord. I may be outstated from my post, my lord. That may be, my lord.
32.
How can I pass an order to that effect?
My lord, I am in apprehension.
Understood. When they say that you are no longer in service, how can I say you are not there? I am asking about the status. If nothing happens on Monday to Wednesday, we'll see. Yes.
Here I have received an instruction, my lord. The condonation of shortfall of qualification service has been condoned, my lord, by the government, and the file was with the government, my lord. Today,
the condonation of solar could not be communicated to the PO for convert submission of the types of pension as the original.
Just now, my lord, I have received information from the government, my lord. They have returned the file to the directorate yesterday evening, my lord. So now director will send it to the DO to honor submission to the director of pension, my lord.
He's asking for what?
Pension, my lord.
Pension full or provisional?
My lord, the problem is there. The provisional pension has not
Shortfall,
been
my
paid.
Huh?
Provisional pension has not been paid. Although the petitioner retired from service on 31/5/2010, and interim order, this honorable court has passed on 28/9/2022, directing them to release the provisional pension.
Yes, why not provisional pension have been paid?
Right now, my lord, that information I don't have, my lord, regarding provisional pension. But the shortfall was condoned, my lord.
Shortfall of what?
Qualifying service, my lord.
Hello.
That has been condoned by the government, my lord. And now
How much was the shortfall?
I think the total service period was, my lord, 9 years, 2 months, I think.
9 years, 3 months, 18 days.
So, how are you entitled to provisional pension?
That is as per section lordship 67, rule 67. The governor can lordship condone the.
Understood.
That
But
has-
till it is not done, how are you entitled to provisional pension?
But there isn't.
Are you not entitled then to only terminal gratuity?
Nothing was paid lordship till date. Your lordship, there is an interim order on 28/9/2022. Despite of this court order, lordship.
So I'll modify it.
And that when your lordship has passed some district order on last August 3/5/2023, thereafter the file is moving.
So obviously, when orders are passed to like this, only things work. But whatever may be, as of now, they have only condoned.
Their direction was lordship on.
Nothing was
2/12/2000.
coming from the office of AR. So let us wait for some time.
Yes, madam.
Well, at page 28, there was an earlier direction.
Mr. Khan,
Hello.
kindly appreciate. Heard Mr. Khan, M. Khan, the learned counsel, appearing on behalf of the petitioner. Mr. N.J. Khatonia appears on behalf of the
Elementary education.
Elementary Education Department. It has been submitted by the learned counsel appearing on behalf of the Elementary Education Department that the government had accorded approval for condonation of the shortfall of the qualifying service for pension by invoking the powers under Rule 67 of the Assam Service Bracket Pension Rules 1969 insofar as the petitioner is concerned. By the communication dated 23rd of May 2023, the Director of Elementary Education had requested the Secretary to the Government of Assam Department of School Education for the purpose of returning the original service book and all other pension-related papers of the petitioner for immediate compliance of the orders so passed by this court in the present petition. It has been further mentioned by Mr. N.J. Khatonia, the learned counsel, appearing on behalf of the Elementary Education Department, that he have also been verbally instructed to inform this court that the government of Assam Department of School Education had yesterday means today, 24th, on 23/5/2023, have already returned the service book along with all related pension-related papers of the petitioner to the Director of Elementary Education. And the Director of Elementary Education is accordingly taking appropriate steps. How much time?
1 week, my lord.
The learned counsel, standing counsel, therefore submits that a further week's time would be required for finalizing the pension.
No, to send it to the Director of Pension, my lord.
To send the papers to the Director of Pension. Accordingly, list the matter again on 28th of June 2023, on which date the learned counsel appearing on which date Mr. S.R. Borwa, the learned counsel appearing on behalf of the respondent number 3, shall apprise this court as to whether the pension proposal have been duly received from the Director of Elementary Education and what steps have been taken by the Director of Elementary Education in that regard. It is relevant to take note of that the petitioner had retired on
31/5/2010.
31/5/2010, and almost 13 years have elapsed, and as such, the Director of Pension, as well, the Director of Elementary Education, as well as the Director of Pension, shall do the needful so that the petitioner gets his, the pension of the petitioner is finalized as early as possible.
Obliged, Lordship.
Instruction so submitted is kept on record and marked with the letter Z.
Obliged, Lordship.
33.
Yes.
Your Lordship. Lordship, on last occasion, I was asked to apprise the court on the time in which his arrear salary may be disbursed, Your Lordship. I received the instruction, his arrear salary has already disbursed.
Claiming the amount along with interest that so the question of interest in terms here would be taken up at a later stage. However, the standing counsel for the Highlands shall apprise this court on demand as to when the amount shall be disbursed to the petitioner. Yes,
Yes,
when?
Your Lordship.
You got it?
Yes, yes, Your Lordship.
Now, what about the interest? You are on interest? Forget about this interest. You got the money.
Only his TA arrear amounting to the so and so is to be given because there's insufficient allotment of fund, Your Lordship. Only his TA arrear is pending, Your Lordship.
Then, has he got 2,45,000?
There's an arrear salary, Your Lordship.
Has he got it?
Yes, he got it.
So TA is remaining.
Yes, Your Lordship.
But TA is not his part of his claim?
No, we have claimed it
Where?
in page 9,
No.
paragraph 15.
No, you have not asked for. Where is it? To make payment of the remaining retirement benefits which the petitioner is entitled to at earliest? To make payment of the interest on making delayed payment? And where is the area payment? When are you paying this 1,04,000?
Lordship, we have already, it is under process. We have already returned to the PCC.
How much time?
Lordship, as soon as possible we can do it because we have
Soon
already.
as possible. You have forest?
Yes, Your Lordship.
Forest has a lot of money. When?
Lordship, I have to take the instruction after 2 weeks at which time we can do that.
Heard, Mr.
M.R. Sodial.
M.R. Sodial, the learned counsel appearing on behalf of the petitioner, Mr.
R.R. Gogoi, Your Lordship.
R.R. Gogoi appears for the Forest Department.
Respond number 1, 3, and 5.
For the Forest Department. Mr. M.R. Sodial, the learned counsel for the petitioner, had submitted that the petitioner have already received the amount of rupees 2,45,182, which is the area salary. However, it is seen that the petitioner is further entitled to an amount of rupees 1,04,890 on account of TA area. However, the same has not been paid on account of insufficient allotment of TA budget to the division in concerned division, as have been mentioned by the divisional forest officer, social forestry division, to the principal chief conservator of forest and head of the forest force by the communication dated 13/2/2023. The said communication has been furnished to have been placed before this court during the course of the hearing by Mr. R.R. Gogoi, the learned counsel appearing on behalf of the Forest Department. The same is kept on record and marked with the letter X. The learned counsel for the Forest Department further submits that the department is processing the same, and immediately upon receipt of the fund, the same shall be paid to the petitioner. So accordingly, let this matter be fixed again on 21st of June 2023. It is expected, this court expects that the said amount be released to the petitioner in the meantime.
34.
Court hopes and expects.
Lordship, in this time, I require some more time, Your Lordship, because we are communicating.
Mr. Gogoi,
Yes, Your Lordship.
if you don't pay that amount, 197 will apply. Ask your people.
Yes, Your Lordship. In this matter, I request some time, Your Lordship. We asked for expedited the subsistence allowance.
Regarding what?
Subsistence allowance, Your Lordship. That has not been paid yet.
Why you have not paid?
They were paying, all of a sudden they have stopped. The reason I have asked for them. 34. Oh, sorry.
You are not there. No, you are not there.
Sorry, Your Lordship.
This is why I was looking into it. Yes, Mr. Jalan, Mr. Borbujari, and Mr. S.K. Modi. Yes. I have submitted that the amount to which the petitioner would be entitled to on account of area pension have already been calculated and details of which have been already sent to the office of the Mr. R. Borbujari, the learned counsel for he has submitted the have been duly received on demand, and the same has thereafter been forwarded to the office of the accountant general on it. Taking into account and let the matter be listed on which the SK is released. Yes, Mr. Mehdi. Who appears for the accountant general?
As per instruction, Lordship, AG has returned documents to the Treasury officer, filed letter dated 16 May 2023. Because the computation sheet of area of pension for the period with effect from December 2014 to November 2020 was neither in prescribed form nor countersigned by the Treasury officer, Lord.
Oh, the Treasury officer has sent it just for the sake of formality.
I have been served a communication of that.
Mr. Borbujari, it is a very serious thing. Why the Treasury officer has done all these things? He knows that he has to countersign it, I think, or is he new?
As per the instruction, my lord, received earlier, my lord, in my WhatsApp, and I have personally checked it, my lord. He has done everything, my lord.
Then,
further rules.
Then why is the accountant
I
general
will
saying
have to
something
take-
else?
I will have to take further instructions then, my lord.
It's a very serious thing. This is written by the accountant general. In inviting your appearance on the subject, I am to state that the calculation sheet for undrawn area pension is to be furnished in TR form 20. After duly countersigned by the concerned Treasury officer for obtaining necessary sanction from the government of Assam. In this connection, a computation sheet of a pension for the period from so and so furnished by the SBI as forwarded neither in prescribed form nor countersigned by. You have also not sent in the prescribed form. As such, I am to return herewith the documents received by letter under reference in respect of so and so with request to resubmit the same after meeting up the observations. Then, what have you done thereafter?
Lordship will fix this matter immediately after 1 week, my lord. Let me get the instruction on the basis of.
No, I'll fix it on 16th of June. Do whatever it is required, you can do it and finish it off. There's nothing, no problem. What prescribed form has to be done, how it is to be done, both of you know. Not you, I'm not saying the lawyers will know, these officers will know.
Yes.
Copy of this communication has not been furnished to the State Bank. And regarding State Bank, my lord, they have not said that State Bank has not furnished by the SBI Bihali branch so and so dated so and so as forwarded.
Furnished by the SBI so and so, dated so and so as forwarded neither in prescribed form nor countersigned by the Treasury officer.
My lord, kindly take note of, because here, my lord, not only the Treasury officer, my lord, the administrative department sanction is also required. Kindly see. I am to state that the calculation sheet of undrawn area pension is to be furnished in TR form. Okay, my lord, this is a formality. After duly countersigned by the Treasury officer, that will also be done for obtaining necessary sanction from the government of Assam.
For obtaining.
Yes.
That is why then only the accountant general will send.
Yes.
Heard, Mr.
Yeah,
J. Abbas, the learned counsel appearing on behalf of the petitioner. Mr. R. Borbujari appears on behalf of the Treasury officer. Mr. Your name?
KK
Medhi. KK Medhi appears on behalf of the Accountant General AE. Mr. G. Jalan appears on behalf of the State Bank of India. In pursuance to the order dated 19/4/2023, the learned counsel appearing on behalf of the Accountant General AE have placed on record a communication dated 16/5/2023 issued by the Senior Accounts Officer to the Treasury Officer Lakhimpur Treasury. From a perusal of the said communication, it reveals that the calculation sheet of undrawn arrear pension, which is required to be furnished in TR Form 20 after duly countersigned by the Treasury Officer for obtaining necessary sanction from the government of Assam has not been done. Inasmuch as it has been mentioned that a computation sheet of arrear of pension for the period with effect from December 2014 to November 2020 furnished by the SBI Bihali branch by reference number BMSL/2023-24/07/01 dated 3/4/2023 as forwarded neither in prescribed form nor countersigned by the Treasury Officer. It is under such circumstances the Senior Accounts Officer had returned the documents with a request to the Treasury Officer to resubmit the same after meeting up the observations of the office so that an admissibility report may be issued for obtaining sanction from the government at the earliest. The learned counsel appearing on behalf of the respondent number, Jalan is
6. Respondent 6.
Huh?
Or 6.
And Mr. Arbor Pujari is Treasury is item number, respondent number. The learned counsel appearing on behalf of the respondent number 6, 5 and 6 submits that due action will be taken in terms with the said communication by the officers concerned. Let this matter be listed again on 16th of June 2023, on which date the learned counsels appearing on behalf of the respondent number 5 and 6 shall apprise as to whether there has been compliance to the request made by the Senior Accounts Officer of the Office of the Principal Accountant General AE in its communication dated 16/5/2023. The learned counsel appearing on behalf of the Accountant General AE shall also apprise as to what steps have been taken if such proposal have been resubmitted by the respondent number 5 and 6. By the respondent number 5.
5, my lord. Because in this communication, there is no mention about
Yes,
this.
5,
No copy
5,
has been
5.
served. Only 5.
Okay. The instructions so received, so the instructions so placed on record by the learned counsel for the respondent number, where? Respondent number 3 is kept on record and marked with the letter Y.
My lord,
Taking into account the actions you have been doing like this, I should now start not from marking from X. It has to be from P.
my lord, only one prayer, let the name of SC Finance be shown in the cause list. Now, otherwise, every time we are skipping the file, my lord.
Yes. The name of Mr. Arbor Pujari appearing on behalf of SC's Finance be shown in the cause list.
I'm so obliged.
Lordship, can it be date 15th?
Huh?
Can it be picked on 15th, Lordship? On 16th, I have.
15. This is a pension matter. You want to change the nomenclature? 15, I don't take a pension matter. Yes, next. Have a Mr. Abbas, I won't disturb you. If you are to get, you'll get it otherwise. I don't require the petitioner lawyer. And this is, for pension matters, it is not required. So the inconvenience is not relevant.
I'll be seeking a copy of this communication from my learned colleague.
Huh?
I'll be seeking a copy, my lord.
Yes, you do it very well.
Yes.
Yes. Mr. I already sanctioned the provisional pension of the wage which would be paid to the petitioner with effect from Iman till the Iman, the letter of communication. Is again fixed on which state the learned counsel for the PWD as well as the learned shall apply as regards the status of pension and yes, PWD, no PWD. And accountant general, any instructions?
I've received that.
You have got the provisional pension?
No,
Why? They have already fixed it.
no provisional pension.
Have already been sanctioned. That is what they are saying.
My instruction is that I am not yet received. Your Lordship.
Mr. Ardhar is not there. Yes, well, what document is that?
Lordship, I'm pension paper not received. Pension paper not received.
You have not received from PWD?
Lord. And in respect of provisional pension, Lordship, department is the authority to release.
And heard Mr.
R. Majumdar.
Huh?
R. Majumdar.
R. Majumdar, the learned counsel appearing on behalf of the petitioner. Mr. R.K. Talukdar appears on behalf of the Accountant General AE. Mr. R. Majumdar submits that from the instructions so received when?
Last week.
From the instructions so received, the petitioner have not received the provisional pension. When did you take it? Can you ask, you have your phone now?
Actually, I have been engaged in this case.
Huh?
Your Lordship. JMMU law school is there.
Where is
He is
he?
instructed. No, he is
None
there.
appears for the petitioner.
No.
Then-
My name is also there.
Then your name is there,
Last
then
petition I
why?
appeared.
If you can't take instruction, you don't get a better order. I'm taking it, telling
I
you.
have specific instruction that.
You have instruction only last week. We are not concerned last week because I'm going to ask the personal appearance of the chief engineer PWD. Get the instructions.
5 minutes, Your Lordship.
Yes, I will take you at 4. I'm giving you 20 minutes. Get your instruction.
37 and 38.
Yes, why both the same matters? Miss A. Bhachaji, yes.
My lord?
Oh, that matter, both.
Yes.
Yes, there is something on one matter, somebody is saying less my amount and the other matter somebody. The learned counsel appearing on behalf of the petitioner in so and Mr. B. Bora, learned counsel, I have heard Mr. R. S. Dowry, learned counsel, appearance of both the requisitions show that while in petition number so and so, petitioner's only relief which can be granted is payout for area salary. On the other hand, in the petitioner number 1, who is the petitioner in so and so, claims an amount of rupees 1,85,000 as the area salary from so and so to that, nothing more than that. Therefore, in the meantime, the for the result shall obtain instruction as what is the exact amount of area salary the petitioner is entitled to and what period. For the respondent shall apply whether there is departmental or judicial verification. Yes.
Yes, in item number 37, I'm appearing. In item 37, I am seeking the earned leave for a particular period. And in item number 38, my friend is appearing. And in 38, I think he is better to raise the facts.
Lordship, in last petition, instruction was sought for exact amount of outstanding amount, Lordship. And after then, the petitioner wrote a letter seeking for statement from the director of some Foundation of Development Corporation, and accordingly, she has issued a statement, my lord. And as per this statement, the petitioner is to get 3,65,295 from the date of suspension till date of retirement. Lordship.
Inclusive of everything.
Yes.
Earned leave also.
Yes, sir.
Both.
Period of suspension.
This is not inclusive of my claim.
Mr. Counsel, I don't understand. One person, two lawyers. Two lawyers are asking for different amount. One says that my amount is total is this. You are not able to finalize amongst both of you. What is the status?
May I clarify? Lordship?
How can I help you?
May I clarify?
Don't keep on clarifying all these things. Govinda Rajbangshi, yes. What is this? Establishment half pay period from so and so to so and so. Dearness. This is so and so. And what is this? Salary bill of so and so under suspension. Then to be paid, already paid. As per this document, which has been given when? Mr. Counsel,
Lordship,
when did you get this
it
document?
was issued on last 25 2020.
My lord, right now, my lord, another MD has been posted, my lord. So I need further instruction regarding that document. He have not given me. Yesterday only, my lord, that instructions he have given me, that whether judicial proceeding or departmental proceeding is there, my lord. And he have, as per official record, there is no departmental proceeding and judicial proceeding, my lord. So I need further, my lord, instructions regarding these documents, my lord. Because earlier MD has been transferred, my lord. A new MD has come, my lord.
But I want to clarify a confusion, Lordship. My period starts from Lordship 2011 to 6/3/2012.
Mr. Counsel, are you both not appearing for one person?
Yes, sir.
Can both of you undertake to file an affidavit what he is actually entitled to?
Yes, Lordship. Yes.
Any of you?
Yes, yes.
You say how much, you say something else, I'm not. Let the petitioner say. The petitioner happens to be one, we have two counsels. One counsel is not agreeing to the other. We are not concerned with that. You give an affidavit how much it is.
Yes, I'll file it, Lordship.
Because how can this court decide when the petitioner, lawyers are fighting, not the petitioner?
There's no fight. Lordship, I'll file one.
Then?
affidavit, Lordship.
I'm not worried with all these things. How much a person is going to get. You have a dispute amongst your lawyers, what will happen now? Obviously, the respondent will take benefit. Your name, both of you? Your name?
B. Bora, Lordship. I'll file it.
You are B. Bora?
P. Colita. P. Colita.
B. Colita. The learned counsel appearing on behalf of the petitioner in WPC number 2388/2020 and Mr. B. Bora appearing on behalf of the petitioners in WPC number 1557/2023. I've also heard Miss R.S. Deori, the learned standing counsel appearing on behalf of the Soil Conservation Department as well as the Assam Plantation Crops Development Corporation Limited. This court by an order dated 28/4/2023 directed the counsels appearing on behalf of the same petitioner, namely Sri Govinda Rajbangshi, as to what is his entitlement. There seems to be some confusion amongst both the counsels, although the petitioner happens to be the same. Be that as it may, the petitioner, Sri Govinda, the petitioner in WPC number 1557/2023 is directed to file an affidavit indicating as to what is his exact amount to which he is entitled to from the respondent number, whom? Respondent number 4.
Respondent number
4. 4. Again, you are confused. You can't get it from here.
In my case, it's
No, I'm not. From the respondent number 4. So, Miss R.S. Deori, the learned counsel appearing on behalf of the respondent number 4 and 5, submits that as per her instruction, there is no departmental proceedings or judicial proceedings initiated against the petitioner. She, however, submits that a new managing director has joined in the respondent number 4 corporation, for which she would take appropriate instruction. as regards the entitlement of the petition. List the matter again on 21st of June. You take this.
Yes.
I am giving it to you. He is not giving.
Thirty-nine.
Yes.
Lord, yeah, Lordship will allow me some more time to get the written
Mr. Bora, it has become a habit.
I am not getting a written instruction, my Lord. Yeah, my Lord.
Understood. All your departments, wherever you appear, there is always your time. You are asking for time.
So it will be
Huh? What is to be done?
the charge allowance.
Luckily, I disposed of those suspension matters. Again, the same would have happened to you. Yes.
Because this is regarding charge allowances, my Lord. The charge, whether this person will get the charge as long as the others.
Ah, that matter.
That matter.
Yes,
Lord. Only the
It's
charge
a
allowance.
simple matter where it has already been given by them.
But no, it has been given to the Mayoine Council, had decided and given to 2%. Whether
Ah.
he also entitled to, my Lord.
Yes.
Only thing is that let me get a written instruction, my Lord. But the
Written,
charge
they are
allowance-
not giving it. Then why shouldn't I follow the same?
Charge, my Lord, charge allowances has been given, but there is no specific whether which, how they will be calculated and all these things. It will be 1% order, 1,000 rupees per month. So let them have some time, 1 week time, my Lord. I'll get the written instruction.
Mr. S. Bora, the learned counsel appearing on behalf of the
Make please.
1, 2, and 3, man.
respondent numbers 1, 2, and 3 submits that he has not received his instructions pursuant to the order dated 15/5/2023 passed by this court. He further seeks for an accommodation of a week. Accordingly, list the matter again on 7th of June.
Forty.
Yes, please, Your Lordship. On the last occasion, your lordship was pleased to direct the standing council for his department to inquire of the stage of the department proceeding. And
For the
also
forest
as to why-
shall apprise you on the returnable as to what is the stage of the departmental proceedings so initiated and when is it likely to be completed. Further to that, the learned standing council for it shall also apprise you whether as to why the area subsistence allowance for the period have not been paid. Yes.
My Lord, I got some verbal instructions that department was in no receipt of his reply, though his annexed here, my Lord. Annexed at page 50. It bears the seal, but department is not in the receipt of his this reply to the show cause, my Lord. So it was stalled. So accordingly, I send this that you have a seal. So now they're processing, my Lord. PO and IO will be very soon as soon appointed. And my Lord, very few on 18/11/22, my Lord. Prosecution sanction has also been granted. And as regards subsistence allowance, my Lord, this file is still running. My Lord, will direct, my Lord, to forfeit release, my Lord. Otherwise, my Lordship will direct to regularize that period and forfeit release the subsistence allowance. But that file is still, my Lord.
Regularize which period?
That period of suspension, my Lord.
How can I direct?
Why? My Lord.
How can I direct that?
This is
There is a case that why area subsistence allowance for the period so and so had not been paid.
Yes, my Lord.
Why should I regularize it? Isn't it your duty to pay?
It's our duty to pay, my Lord, but
Then
this
why
file,
haven't you paid it?
This file is, my Lord, they're still sitting up, processing and sitting over, my Lord. I tried to take decision. Some instructions.
And after doing it also, nothing is happening.
My Lord, I also.
Who is the authority concerned? Who is the authority concerned?
Subsistence allowance, my Lord, he wrote to the PCCF.
We call the PCCF then.
No, no, calling would not
Respond
be,
number 3 to where, yeah, as to why he is
my Lord,
sitting over
inviting
it.
him would not be, my Lord, if my Lord gives a direction, my Lord.
No, why should I give a direction?
within-
Isn't it your bound and duty? to?
Yes, but it's our
I can give a direction if you want that you are willing to pay interest also. Are you willing to pay interest? Then I can give a direction. Otherwise, not necessary. They are bound and duty to pay. How is the person going to survive? You have
No,
not
he's
paid.
been reinstated, my Lord.
Understood. But what about this earlier period? He must have taken loan. Have you?
No, my lord, he
Yes,
doesn't
how
need
will
loan.
he survive?
He doesn't need loan, my lord. The charges are very serious, and my lord,
Charges,
very-
no, charges are.
he's an enriched person. He doesn't.
These are charges, not true.
He doesn't need loan, my lord, because he has explained in his show cause that what amount of property he possesses. He doesn't need loan, my lord.
Here, your lordship, they have paid substantial amount for some period, and for some period they have not paid. Whether there is requirement, any requirement for regulation that period.
No. The regulation
No, that
is
part
not
is
there.
No,
You have to pay that subsistence
Yeah,
allowance.
I'm not disputing his claim.
Then,
Every time I stand, I
then
don't
why
dispute,
should I
my lord.
direct?
So, my lord, since to interest of justice, my lord, this file is circulating, my lord.
and regarding another submission, your lordship, after filing of the show cause, I have filed a reply. Even if they have not received any reply, they are always at liberty to proceed further with the department proceeding.
That is his own
For
interest, my lord.
you, some other, for you, the law rule 9 does not apply.
No, my lord, they are waiting since.
Forest
this reply.
department is a different thing. It
No,
has happened.
they are waiting,
Two
my lord.
departments,
They
both
are-
of you appear. One is the forest under the PHC. They think they are above everything.
No, they had been waiting. When only I pointed
Like
out to them
it
that
is there in many cases, na,
Yes.
that it shall apply to everything except the state of J&K. It should be rendered that everything will apply to all departments except the departments of forest and the PHC. But Mr. D. Gogoi appears.
My lord, since I accede to his prayer, my lord, nothing else. My lord, but since I pointed out that they are, I pointed out that.
Okay.
Very sweet, my lord. Yes,
Or
I-
Mr. R. Mujumdar, the learned counsel appearing on behalf of the petitioner, Mr. D. Gogoi appears on behalf of the respondent number 1, 2, and 3. During the course of the hearing, the learned counsel appearing on behalf of the forest department submitted that the department in question was not, the department in question was not aware that the petitioner had submitted the statement of defense. However, when the copy of the writ petition was served upon the whom? Mister,
My lord,
from whom? To whom did you give it?
my lord, I pointed out to the secretary, my lord.
Was pointed out, the copy of the writ petition was served upon the secretary to the government of Assam Environment and Forest Department. It came to light that the petitioner had submitted the statement of defense. It has been further submitted that in terms with that, the department is in the process of appointing a presenting officer as well as the inquiring officer in terms with appointing a inquiry officer and the presenting officer in terms with Rule 9.4 and Rule 9.5 of the Assam Service Bench Discipline and Appeal Rules 1964. As regards the question of subsistence allowance, area subsistence allowance for the period from 1/6/2021 to 18/5/2022, the learned counsel appearing on behalf of the Forest Department submits that in terms with the provisions of FR 53 of FR and SR as applicable to the state of Assam, the petitioner, if not paid, the subsistence allowance during the said period would be entitled to the said amount. So taking into account the said submission, this court therefore directs the secretary to the government of Assam Environment and Forest Department to pay the subsistence allowance for the period from 1/6/2021 to 18/5/2022 within a period of 3 weeks from the date of submission of a certified copy of the instant order upon the secretary to the government of Assam Environment and Forest Department. As regards the departmental proceedings, this court fixes the matter again on 28th of June 2023, on which date the learned counsel for the Forest Department shall apprise as to what is the status of the departmental proceedings.
Your lordship, may I point out, your lordship, in the appendix, the secretary, there is a new nomenclature, your lordship. It would be, there is a change in the nomenclature.
Of?
the secretary, it will be now additional chief secretary.
No, my lord, additional chief secretary remains. Secretary is secretary because everything remains, my lord.
And regarding your lordship, 36, I have instruction, your lordship. No payment, lordship. Even it has not reached the executive engineer office.
We call the executive engineer.
My lord, on the last occasion, I have placed a document with your lordship.
But then also they have not done it. You can't help it. That was done on 11/4.
My lord,
This is a very serious thing.
my lord will fix the. My lord, I'm giving my undertaking, my lord. My lord will fix the matter next week, my lord. Any day, my lord. In these 2 days, next 2 days, my lord, I will make them do it, my lord. Why? Because, my lord, I have on the last occasion, my lord, I have submitted before your lordship. I have placed a letter even, my lord. Letter dated 1/4, my lord. So, my lord.
And he has not received the pension papers also. That is what he is saying. No, this is a very serious lapses on the part of this executive engineer or the so who? So the secretary PWD.
My lord.
Who has done that? Additional secretary of secretary.
Yes.
Who sends the papers?
Obviously by the secretary.
It has to be sent to the accountant general by whom? Oh, this is serious.
It will be sent by the respondent number 2.
I am very concerned. Mr. Dhar, I was expecting PWD in a better pedestal than PHE and the forest. They are getting worse.
No, my lord. There is an issue also, my lord. What happened? Last 2 months we have been with PWD, my lord. We are going for digitization, everything. All these files, my lord, were taken to a locker room and we faced serious trouble, my lord.
Are you saying that if we also go for digitalization, the courts will be shut down?
No, my lord.
Then
I'm not, but my lord, there are.
Go and tell the Chief Justice that don't go ahead with the digitalization because the courts may shut down.
No.
The people may not get the relief.
My lord.
Then don't make all these excuses.
My lord, document refuse করছে জ্ঞান বলে এই যে করে পাইছেন এর আরে মানে ইনফরমেশন দেন 1510 no my lord will I have placed a document, my lord, letter that was
was that no, I'm asking you.
April 23, my lord.
I understood, but whether this is an eyewash, they're just making it out there so that for me it's okay and I won't do anything. This was given on 1st of April 2023 and we are in the month of May ending.
My lord, actually my friend
this is the last week.
Accountant general was supposed to take this instruction, my lord. He may have missed
lordship,
it.
It is a letter of April, lordship. I'll take instruction, lordship.
My lord,
my instruction is old, lord.
My lord, this is old.
But Mr. Counsel, Mr. Talukdar, on 11/4/2023, this court passed the order taking note of that order, and you are making this submission.
No, lordship. I'm lordship.
Then,
my lord,
you know what is the consequences of your wrong submission? I was supposed to call the secretary.
Lordship, that letter was in respect of provisional pension, my lord.
Understood.
Lordship, provisional
No,
pension.
no. I am asking you as to whether you have received the papers or not.
No, lordship. No, lordship.
As of now.
Lordship.
When is your instruction?
Lordship, that instruction of October 2022, lordship.
Mr. Counsel, I have asked you on 11/4.
Lordship, first they have to follow. They have to say that the.
That is why I asked you whether they have forwarded or not.
Lordship, they have to produce that document, lordship. Then I can say, lordship. They have to prove that we have forwarded to the paper to the accountant general.
Oh, now I have to look into that both of you have done it or not, apart from what the petitioner decide. My goodness.
And this letter is only in respect.
We are not. I am not concerned. You are one of the executing agents pursuant to their proposal. I am not concerned. You have to take it up with this. I have asked you a specific question. Have you received the papers or not? In all other matters, you can very well come up and say that, look here, I have not received the proposal. And now you are putting the blame that now the PWD department has to prove that he has not.
No, lordship. My brother is showing that letter of provisional pension.
I am not on provisional pension. I have asked you on 11/4/2023. You have any instructions pursuant there too?
No, lordship.
Then why haven't you obtained the instruction? I put your name out there. Oh. Next time onwards, whose name is not required, I'm not asking, I'm not putting their names. Do whatever you like. Heard Mr. Mojumdar appearing on behalf of the petitioner. Mr. Ardhar appears on behalf of the PWD department. Mr. R.K. Talukdar appears on behalf of the Accountant General AE. Mr. Sharma, I am not putting anybody else's name because of your colleagues. I'm only putting because they get confused if I put somebody else's name. The Learned Counsel for the petitioner submits that although on the last occasion, the Learned Counsel for the PWD department has produced the provisional pension document so issued to the Accountant General AE by the Undersecretary to the Government of Assam Public Works Department dated 1st of April 2023, which have been kept on record as annexure and marked with the letter X. Till date, the petitioner have not received any provisional pension. It further appears that this court, on the basis of the communications, on the basis of the document marked with the letter X, had also directed the executive engineer PWRD, Lakhipur Civil Division, to disburse the provisional pension to the petitioner in terms with the communication dated 1/4/2023 forthwith. More than a month have passed by, but till date, the provisional pension of the petitioner have not been credited, as has been informed by the Learned Counsel by the petitioner during the course of the hearing. This is a serious issue and amounts to non-compliance with the order passed by this court. Mr. Ardhar, the Learned Counsel appearing on behalf of the PWD, submits that he would take necessary instructions in that regard, and if the same have not been complied with, the same shall be complied with within a period of 7 days from today. This court further sought the instruction from the Office of the Accountant General AE as to whether the papers pertaining to the petitioner for pension as well as other pensionary benefits have been forwarded to that office. However, Mr. R.K. Talukdar, the Learned Counsel appearing on behalf of the Accountant General, have failed to inform failed to apprise this court as regards the instructions so sought for. Accordingly, this court fixed the matter on 7th of June 2023. It is made clear that if the petitioner does not receive the provisional pension on or before the next date, the executive engineer PWRD Lakhipur Civil Subdivision shall be personally present at 10:30 a.m.
50.
May please. In this case, my lord, my senior Mr. Engineer will appear, my lord. So today, my lord, his health is not well, so he had to leave. So I pray for adjournment for this.
Who prays for adjournment?
I am free.
Why?
On behalf of Mr. Engineer. But his health is not good.
You are asking for a transfer order?
Yes, ma'am.
My goodness.
I'm not asking for a transfer.
Huh?
Lordship.
What is this transfer order?
Transfer order.
Oh, this matter.
Yes.
I remember. That last line.
Last line.
I am not extended. Interim order shall continue till then. Okay. Yes. What is the state?
Lordship, though Lordship, we have not received any instructions, but from this annexure 6 itself, the last line, it shows that, but the Lordship from 14 onwards, in 14 they have been transferred at their own request, and next transfer is in 2023, not within 3 years, Lord. But this sentence, as because Lordship, his request was there, accordingly the TA is not admissible.
If somebody is being transferred,
Lordship.
so Can't he be transferred?
No, my lord.
And that is
was-
too after 9 years.
What is your right?
No, my lord. Being the what is it, the post of junior assistant, my lord. Being the junior assistant, my lord, in the district level post, my lord, the incumbent, my lord, is not normally subject to.
Your name is what?
My name is Puspa Datta, my lord.
Puspa Datta.
Yes, my lord.
You have been posted from Subdivisional Statistical Officer Dhemaji to Subdivisional Statistical Officer Majuli.
Only on the request of
And
the
who has been brought to Dhemaji?
This
Deepali.
yes,
Deputy
Deepali.
Director of so-and-so has been brought to Dhemaji.
Yes.
So, what is wrong?
Only on the request of the, there is no any administrative existence, my lord. In any public.
Enough,
only
enough. Then this court is not interfering with all.
The only for today, my lord. Can you fix day after tomorrow, my lord? My channel will be appear here.
Huh?
Day after tomorrow, my lord.
For what?
Yes, sir, you can will appear in this case. my lord.
Okay, no problem. Subject to cost.
My lord, only.
No, he has appeared today.
Well, my lord.
Who is going to
today
pay?
For the instruction, my lord.
That is what he has appeared. He has come up with the instruction. There is nothing. Now you are seeking an adjournment.
Bringing the instruction.
Then subject to cost of 5,000.
Sorry, my lord.
I won't fix it. But I'm not extending the interim order. Sorry. You want an adjournment? Very well. Nothing more than that.
Let him bring the instruction, my lord.
It doesn't require instruction. Enough is enough. On the last occasion only, I wanted to dismiss it. Earlier, I remember this matter was, the same prayer was made by Mr. MP Sharma. On the ground that Mr. UK Nair is busy with this rule making and all. And therefore, I was taken up. I said that nothing doing. At his request, I fixed today. And now also he is not there. Then
He was there, my lord, but due to some
I'm not.
difficulties, he had.
Okay, you want an adjournment after 6 weeks, but I vacate the order. Heard, mister? Your name?
Eboro, my lord.
Is
Tomorrow,
so
my
and so
lord.
the learned counsel appearing on behalf of the petitioner, Mr. H. Sharma appears on behalf of the respondent number 1, 2, and 3. Full stop. Anyway, the order is already vacated. The matter has to come on 19th of May. Today is what?
Today is
24.
24.
Interim order was only till 20. When do you want? Next year?
No, my lord. Tomorrow, my lord. Or day after.
What?
Tomorrow.
Tomorrow is subject to cost. This is the matter after 4 weeks.
The interim may be.
No, sorry. You want, I can put a line. The interim order passed earlier is not extended. Want that? Be happy with what you got.
Number 22.
Yes.
I'm paying for a little accommodation for today, my lord.
You know, today if you say this will go for 3 weeks. So that is the reason
No,
why.
my lord, because we have to file our affidavit, my lord, but we couldn't do it today. That is why I'm paying for accommodation, my lord.
My lord, I filed my affidavit in reply.
No, reply file করতে? No. Reply file করতে? আমি affidavit দিচ্ছি। আপনি affidavit দিতে লিখুন।
After affidavit.
Oh.
Yes, you have filed your reply.
Yes, my lord. On 22nd.
It's not on record. It is not on record.
And they are supposed to file the affidavit saying why it was not
Yes,
considered. My lord, the criteria is
Mr. Abirin, I remember. Don't worry.
Yes.
But I asked you to file your reply
Yes, fine,
for a particular reason,
Yes, fine.
so that you can bring what I have inquired out here.
My lord, can I hand over a copy?
Not necessary. You are to bring on record that aspect of the matter, that even after now also they have not inquired that aspect of the matter.
Protein, my lord.
Very well.
That aspects.
Mr. J. Abidin, the learned counsel appearing on behalf of the petitioner, submits that the affidavit that the petitioner has already submitted filed the affidavit in reply on 22nd of May 2023. Mr. N.J. Khatonia submits that the affidavit so directed to be filed on 11/4/2023 has not yet been filed. However, he seeks for an accommodation for a day or two. Accordingly, in that view of the matter, list the matter on 12th of June. Which one?
Sorry, Miller. Regarding yesterday's case, Miller, I could collect.
Oh, you got it.
Yes. Yes, that division.
I'm coming from code number.
Mr. Nath, this on that day, yesterday, while dictating, I directed you to approach 3 months. Not necessary, because I thought it would be better that I pass that order to that effect. I refer it to the divisional officer, and the division officer shall then decide in terms with the arbitration and conciliation.
That record should
Within
be
a period.
here.
No, I don't say, because it is already there in the act. The act categorically mandates that you have to complete within 6 months or when it. So there is a period mentioned. So you can do whatever.
Only here, only Miller. In our
That saying
record.
so and so is also posted as the division. In the interest of public service, Assam so and so commissioner is also posted as divisional commissioner, not Assam. In the interest of Manish Kapoor is also a divisional commissioner. Yes, what is all this?
Yes, my lord, what happened? When we filed the case, this notification was not there. 2001 notification was there. At that time, Central Assam division was not there. Thereafter, Dima Hasao come under the jurisdiction of Central Division. That is in 2015. Now, this Central Division is been looked after by next page Miller or first Manish Thakur IS has been detailed. That is the address I also given.
Hills and Barak Valley Division is renamed as Barak Valley Division with the district of Kachar, Karimganj and Hailagandi. Where is this land?
Yeah, Dima Hasao. That is
Dima
first one.
Huh?
First one.
Dima
this
Hasao,
one.
Haflong.
Now,
Now
Manish Thakur or something.
now district is Dima Hasao. Previously, it is a NCL district.
It will come
Okay,
under
where is
Central.
it? Dima Hasao is where? Upper Assam Division.
The
This
Central
will
Assam
remain
Division,
unchanged.
Miller.
The district of Dorong, Mongoldoy, Udalguri are excluded from so and so. The district of Mongoldoy, Udalguri are included in North Assam and excluded from the North Assam division. Oh, Central Assam, a new division with the district of Nagaon, Morigaon and 2 hills district, Karbi Anglong with headquarters of so and so.
Yes.
So now this is Central Assam division.
And that is
And
next
Central
stage, it is
Assam division has a,
looking after by Manish.
I'm not concerned with the person. I'm not going to put
because
it by a
send
person.
the address, Miller.
I will say the divisional commissioner, Central Assam division.
Yes, that's right.
Because if I do that, if I put the name, then it becomes very
Yes,
difficult.
yes. If he's been.
These people may keep on changing.
Yes, yes.
Then the entire matter will go.
This may be
Sure.
recorded.
Hey, this one whole kali order to this one. Well, yesterday I thought about it after retiring. Then I thought that no, why should you go in there? Because otherwise the problem will be if you go there, it will be a fresh reference.
Yes.
And then the period of limitation can't be taken note of.
Yes. Come on, I'll oblige.
23. Item number 23.
Last occasion, my lord, the lordship by order dated, my lord.
Yes, what affidavit? No affidavit. The finance doesn't file affidavit, neither the
Yes,
elementary.
my lord. Here also I am praying for a little accommodation. I have received the instruction, but affidavit could not be filed, my lord.
Regarding what is this?
Regarding my lord, the illegal appointee of Dhemaji district.
Petitioner is an assistant teacher and claims current as well as area salary with effect from March 2014.
Yes, my lord. The illegal appointee of Dhemaji district, my lord, 752. So subsequently, she has been accommodated as tutor, my lord.
He
Yes, my lord.
has joined.
Yes, my lord.
Recall 3 months when after retired.
Huh?
Recall 3 months when after retired.
Then you have joined it.
But-
Have you challenged that?
No, my lord,
Then
not
what
required.
case do you have?
Not required, my lord.
Why?
But my lord, we have no, my lord,
choice, my lord. No has no choice because of that. We have no choice to join. Otherwise, join this post.
So then we dismiss it on the ground that there is already a verification committee holding that you are an illegal appointee. You are only given out there on the basis that you have a salary out there.
No, my lord. There is a court order. It cannot go by within the one appointment, my lord.
Huh?
There is a specific court order
For what?
for giving the salary, my lord.
So
And
how can there be a salary being given if your appointment is illegal?
to file affidavit, my lord will reply giving the.
Not necessary. You have been issued a tutor. You have accepted it. Matter ends there.
No, my lord. We have no my submission is that we have no any other option.
Don't have to have option. You
My lord,
you should have.
they-
You have not
they-
accepted it. You should have maintained it.
They call us in my lord the Khanapara field and they are given crowded 5,000 more than 5,000 people are there and they after giving the.
There are many people who have not accepted it. Mr. Bora, kindly, I'm here sitting in this bench for a long time. I know how many people, there are a lot of people who have not accepted it. And they have not joined.
I am the employee.
Then
I
when you
I-
have joined
I-
out there, you have no
I
say.
have no bargaining power, my lord.
Okay, we dismiss it, go to the division
My lord,
bench.
my lord, without the last occasion, your lordship.
Not necessary.
My lord, on the basis of that, your lordship heard the matter and thereafter.
I'm hearing it.
Yes, no, that last occasion, thereafter, your lordship given the chance to file affidavit, my lord.
You have joined out there, nothing doing.
Well, at least my lord, file affidavit, I will file reply, everything is going to reply and thereafter your lordship, I have no objection. Your lordship has a specific direction is there within a period of after going to the all hearing, your lordship directed. They also submitted regarding that issue and your lordship passed this order. And they did not file affidavit, my lord. They file affidavit, we file reply, your lordship passed order, I have no objection.
No, if they don't file the affidavit, what to do?
What to do, my lord? Then, my lord,
Can I impose upon them to file the affidavit? If they don't file, no file.
They take
But
time, my
then-
lord. They also requested time, my lord. They now requested time, my lord.
They are requesting
received
the
the-
time. They may not
they-
request further when I'm taking this opinion.
They received the instruction, my lord. They file affidavit. At least I am going to some observation in Supreme Court there, my lord. I may be put on that, and thereafter your lordship dismiss my I have no.
What observation?
Because of that, my lord, we have no other alternative. Also, we have no any bargaining power, my lord.
So
because the higher authority put, in spite of specific direction by the honorable court, there is a
if
contempt
you had to
order.
retire after 2-3 months, why did you join at all?
No,
You
my
see,
lord, my area is
telling me,
concerned, my
Mr.
lord.
Counsel, are you telling me that a person, the appointment order is not there? The appointment order categorically mentioned that you have to submit a joining report. There are many people who have not joined. Why have you joined?
My lord, that's why I'm saying.
Happy to join, but then thereafter you say there's no nothing doing.
There is a,
Now I'm back, I require everything.
my lord, area is concerned. I am doing service, my lord. They did not pay in spite of division bench order. They given the undertaking we are going to pay. Thereafter they did not do it. Thereafter they call us and you is gathering give the appointment.
So, but
So, my lord,
doesn't that order of appointment?
No,
No,
yes,
Mr.
yes,
Bora, kindly tell
yes,
me,
my lord, it's
doesn't the
very-
order of
very
appointment categorically say that you have to join?
Yes, my lord. I'm
Why did you join?
sorry to say, my lord, because of we have no bargaining power. I am saying.
So
on the
why you
basis
are
of-
joining? Don't join.
My lord,
There are
for
many.
the purpose of livelihood, my lord. I am doing service last, my lord, for 10 years, the 10 years.
So
then it
if
was
you
10
have
for
for the purpose of livelihood, if you have taken it, then you want to forego that.
my lord, I am simply saying, my lord, your lordship do that. I am not saying, my lord. But my submission is that as per Apex Court judgment, in this situation, my lord, we have no bargaining power. So there were no alternative choice. Thereafter, I've joined, but in spite of specific order by the division bench, they undertaking Advocate General, undertaking to give up, going to comply with the order, and thereafter nothing. Thereafter, just call last retirement 2 months, 3 months before, they give the appointment.
So why didn't you file contempt
My
against the undertaking being given by the Advocate General? Why didn't you file a contempt? You can. Who has asked you not to?
my lord,
That you don't do.
no, my lord.
Then
Yes, thereafter, my lord, there is this order, my lord. After that,
order, many orders are there.
my lord,
But those orders
they
doesn't save you.
give the particular period, and thereafter they did not give. We are expecting that they pay, but they did not. But there is an order, my lord. So many orders are there, my lord. I am my lord, because of that they are retired. I'm coming, my lord. So I'm praying before Lord. They
Because
file
from the
affidavit.
last time till now, I have disposed of many matters in this line.
Yes, my lord. At least
Because the fact-finding inquiry has found your appointment to be illegal. Those people who have been given tutors, do you know?
that fact-finding inquiry, they have to give subscribe to me, my lord. I have to give it
So
given the
then,
opportunity.
then
can
challenge
grant
challenge the fact-finding inquiry. Without challenging it, can you grant it? When there is already a fact-finding inquiry that your appointment is illegal?
My lord, we are not received that.
Not received it. What can be done? You are not receiving, but unless, how can this court pass an order once there is a fact-finding inquiry? Tell me.
How can I say? How can I know that this they issued a fact-finding report?
Oh, see my judgment in Junu Devi. How this has happened, I've recorded everything. That is the affidavit they are going to file. They are not going to file anything new. I've given in details each and everything, what has happened. I put it on affidavit. The affidavit which they have put it. In every case, this is happening. But unless and until you challenge the fact-finding inquiry, how do you take note of? Because you are having this problem. You have to challenge the terms and conditions about accepting the tutor. Can this court today, in view of that particular document being produced and you have joined out there, can this court say that no, then also you have to pay? When you have waived?
Regarding that issue,
Mr. Counsel, kindly listen. When you have waived, unless you say that look here, I have waived under compulsion. I didn't have it. There is a bargaining power, and as such, to set aside that particular condition. Unless you do that,
yes,
can this court pass an order in this petition?
That's why, my lord, they file an affidavit. I will put on record.
No, you know that you have joined it. Why you have not challenged it by filing a writ petition? That order. You get a handle then. You understand the point, what I'm saying?
Yes, I'm
As of now, this court cannot.
Yes, I'm
Let me tell you what has happened again, which I have been keeping on repeating out here. Initially, 2010 screening committee was formed. There were 5 divisions found. Of these 5 divisions, they've given 4 reports: category 1, category 2, category 3, category 4. You fall within the category number 3. Those who have not been recommended but received salary up to 2007 and above. You fall within that ambit, which consists of 8,470 teachers. Thereupon, there was a decision taken by the government that look here, we are going to remove these people by issuing a show cause. And or asking them why they should not be, to show that they are legal appointments. Then the government took a decision and said that the minister, as well as all these 8,004, they have a union. So they went out there and found out, and the government minister said that look here, we are going to have another committee. Now this committee recommends 3 types. One, the least one is in respect to those persons who had qualification and received salary till 2007. That is list 1, who have been made teachers. List 2 are those teachers who did not have the qualification till 2011. That is the tutors. And third is 7,000 odd teachers who did not get anything. They didn't get any salary before or anything, so they didn't get it. You come under category number 2, that is you are a tutor. So there is already a finding of fact. Now this finding of fact you need to challenge. Otherwise, how can this court pass an order in your presence? Tell me. You sit as a judge and tell me, is it possible for this court to pass when there is a finding on fact? They have not filed the affidavit till now, it is okay. But the moment they file, your case is dismissed on that day. I hope you understand. At the request of Mr. N.J. Khatonia, list the matter after 4 weeks.
In the meantime, I will take. In the meantime,
I hope you understand now.
24.
May result.
Yes.
The petitioner is assistant teacher, Lordship, appointed in 2009.
Issue rule. Why it is being admitted?
Lordship.
BTAD, after coming into force of provincialization rules, amendment rules of so-and-so, Iman issued by Iman to give a benefit of the
We had
My
increment. Your
goodness. Oh, this is the same matter.
We had increment, but he had been receiving the increment, but from September it has been stopped. Your Lord. For 3 months he got the increment, but
Then?
suddenly from September he has not been getting the.
Why?
increment, Your Lord. Because we don't have the instruction, Your Lordship. Maybe because there was a notification where.
No, you see, there is a notification of this particular date, na? What is
Lordship.
that? 12/5/2022.
Lordship.
No. There's a notification of
21/7/2000.
yes, something to that effect.
Lordship.
Whereby it requires the twin requirement.
Lordship.
Be B.Ed or
from the
D.Lit or something from that particular university, regular recognized university, and second he has to from 37.
37 2012.
37 or 37?
Lordship 37, 2012.
37 2012.
37, Lordship. Page number 232, Lordship.
Page?
Honorable, page number 32, Lordship. Honorable Court Order, Lordship. He and she had joined before 37, 2012.
We dispose of to make the verification. You submit your representation and you have my order.
Lordship, I have an order.
Okay, we dispose it. Please hold on. Naam to lo. Your name. My goodness, this is rule has been issued. This one, this document, 21st of July 2016. He has joined on 37. I am right, 37, not 37. 37/2012.
Lordship.
And obtained B.Ed degree from UGC recognized so and so approved. So you submit a representation and thereafter you give it. Before, and this will require verification from the SWEA of the inspector. Inspector of schools, huh? Respond number 3. Chalo. Economote di dibo, huh? Dispose of koi dibo. Where? Okay, ito kaam karo. Madam, you are appearing for 1, 2, and 3, na?
Lordship.
And 3. B Chaudhary not required. This not required. This not required.
120.
Man. Coordinate pension taking into account the this board is also if the petitioner have required that the degree from the in 1 month. Submit the Now, in this case, you have got some increment.
Lordship, 3 months increment. 3 months.
From which period?
July, August, June, July, August.
Of
2017.
2017. It is made clear. The line it made clear that the inspector of school How many petitioner? One.
Well,
That earlier received the advance increment. Advance increment, na?
Lordship.
For the period from
September 2017, Lordship.
to
2017, Lordship. I have not received, Lordship.
no, earlier from when?
June
From June 2017 to September 2017. And thereafter, The paragraph theta got value, huh?
Lordship has received till August.
Huh?
Till August. August.
June, July, August,
July,
I have received.
June, July, August he has
Lordship,
received.
Lordship.
September, yes.
August. June to August. I've just added out there, it is made clear that the inspector of schools shall take note of the fact that the petitioner had earlier received the advance increment for the period from June 2017 to August 2000 and thereafter have not received.
Deeply.
Lordship, 27 is also similar, Your Lordship, on BA trimester.
Same?
27.
In this case, my lord,
You will come up with something else, yes.
it's not just
Lordship.
there was an impugned order, my lord, at page number 62, whereby my second round of litigation, my
This is 27?
yes,
I got to 26.
26 is there. Your Lordship.
Eh? Nikita Matilo.
25 and 26.
Yes, petitioner, madam.
Lordship, I have challenged the show cause notice dated 4/7/2008.
For what?
Under
Challenging
Rule
what?
9 of the against the petition actually. 4/7/2008 notice issued by the Director of Elementary Education under Rule 9 of Assam Discipline and Appeal Rules, Lordship. And in this case, notice was issued on 13/3/2020. Lordship.
Nothing has been done beyond the. What are you claiming, madam?
I'm claiming as setting aside this order, Lordship, because in the name of pendency of this disciplinary proceeding, they have not released my pension, regular pension and other.
When did you retire?
He already retired on 39/2018.
39, 2018.
Yes, Lordship.
So before that, they issued the show cause.
Yes, Lordship.
Okay.
Then I wanted to inspect the document.
Okay, we asked them what has happened.
Yes, Lordship.
You have submitted your reply.
No, Lordship, they have
Lordship,
not
what
filed
has
any
happened
affidavit
is-
in opposition till today.
No. Have you submitted a reply to the memorandum of charge?
No, Lordship, because
Why?
I wanted to inspect the documents. At that time, they have taken up with the documents that were not available in the department. And earlier, the petitioner was denied his promotion, Lordship. And in that case, also I approached this honorable court
Allow me to
earlier
check
on
all the
2015,
documents
Lordship.
and the
And the honorable,
I have not received any reply.
and that is in annexure 6, Lordship, page.
Okay. No, madam, the problem why this is happening is that we need to formalize this matter properly.
Yes, Lordship.
Once we ask them the properly, the direction, then only things will come. If this type of order is being passed, there the problem arises. We passed this first order and the second order is for pension. Huh?
Yes, Lordship.
Are you getting the provisional pension?
Yes, Lordship.
You are getting.
I am getting.
It a matter divided 1952 and 1962. Or Miss MD, the learned counsel for the petitioner. Mr. A. Pukon appears for the
My lord, Elementary Education Department.
Elementary Education Department. The case of the petitioner, as would appear from a perusal of both the petitions, is that on 4/7/2008, a show cause notice, a memorandum of charge was issued upon the petitioner, was served upon the petitioner, containing the statement of allegation. Thereupon, it is the case of the petitioner that the petitioner made request for inspection of certain documents so that she could submit their statement of defense. However, the said no opportunity has been given to inspect the said documents, for which the petitioner have challenged the disciplinary proceedings in the instant proceeding. First. In WPC number 1962/2020, the petitioner submits that he had retired on
39/2018.
30/9/2018. And till date, although the petitioner have been receiving the provisional pension, but the petitioner have not, but the pension of the petitioner have not been finalized in view of the pendency of the disciplinary proceedings. In effect, therefore, it is the case of the petitioner in both the petitions that that the respondent authorities are not interested to allow the petitioner to inspect the documents which the petitioner have a right to do so in terms with Rule 9(2) of the Assam Service Discipline and Appeal Rules 1964. And in consequence thereto, the petitioner have not been able to submit an effective statement of defense. This delay has led to the finalization of the departmental proceedings, and for which the petitioner have not got his regular pension. The Learned Counsel, appearing on behalf of the Elementary Education Department, shall apprise this court as to why the petitioner have not been permitted to inspect the documents, as well as what is the present status of the departmental proceedings. List the matter again on.
Anytime next week.
21st June.
21st.
21st.
22nd. 22nd.
Why?
On that day I will be out of station.
Okay, we'll have it on 23rd.
Yes. Apply.
Now I think this will fall in the track. Once you get this order, they will come up with it.
Yes, Lord. Apply. BPM.
27.
May I please? My lord, this is second round of litigation, my lord. So by the impugned order dated 20th February 2020, the Director of Secondary Education held that my B.Ed degree obtained from the IGNOU is not valid. But the NCT, the authority, has submitted the affidavit and clarified that my degree is legally valid.
Your degree?
Yes.
Who says it?
Director, while deciding the issue of my entitlement with regard to advance increment, has rejected the claim of on the ground that my degree obtained from the IGNOU was not acceptable for them. But the NCT, therefore, has challenged it, my lord, in this proceeding. The NCT, by filing the affidavit, has clarified that the degree obtained by me is a valid one. Therefore, I am entitled.
From a UGC recognized university and NCT approved B.Ed college. So you got a B.Ed?
Yes.
Where? So and so from IGNOU, though a distance is a valid degree recognized by NCT on so and so, which is a prior to her degree obtained on so and so. Therefore, the degree obtained by the petitioner is a valid B.Ed degree for all purposes for getting all benefits as per.
Yes.
So we dispose it of. Heard Mr. B. Purkashta, the Learned Counsel, appearing on behalf of the petitioner. Ms. D. Musahari, the Learned Counsel, appearing on behalf of the respondents. The case of the petitioner herein is that the petitioner is entitled to an advance increment.
NCT.
Yes, you have something to say?
My lord,
I don't, and otherwise record names. You have something to say?
we have filed our affidavit. my lord.
Fantastic. Nam to leave your name?
I allow my.
Who appears for the respondent number 5. The case of the petitioner herein is that the petitioner is entitled to an advance increment in terms with the communication issued by the Joint Director of Secondary Education dated 21/7/2016. Inasmuch as the petitioner fulfills the conditions mentioned therein, it is relevant to take note of that as per the communication dated 21/7/2016, the conditions mentioned for being eligible to get the one advance increment for acquiring B.Ed degree is that the petitioner has joined before 3/7/2012, and the petitioner has to obtain the B.Ed degree from a UGC recognized university and NCTE approved B.Ed college. It is the further case of the petitioner that as the petitioner had a degree from B.Ed degree from the IGNOU through distance, the Director of Secondary Education have refused to grant the benefit of one advance increment to the petitioner. The petitioner, being aggrieved, the petitioner has therefore approached this court under Article 226 of the Constitution. It is relevant to take note of that respondent number 5, that is the National Council for Teachers Education, had filed an affidavit on when? No date.
36/21, my lord.
On 8th of June 2021, wherein at paragraph number 5, it has been categorically mentioned. In paragraph number 3 and 5 of the affidavit, it has been categorically mentioned that a petitioner, that the B.Ed degree obtained by the petitioner from IGNOU is a valid degree, as it was recognized by the NCTE through order dated 28/5/1999 for conducting B.Ed distance education for 2 years commencing from the academic year 1999-2000, with annual intake of students per center, will be decided by subsequently on receipt of the details from the for 2 years commencing from 1999-2000. It has also been mentioned that the petitioner passed the B.Ed degree on 25/2/2014 from IGNOU through distance made is a valid degree recognized by NCTE on 28/5/1999, which is obtained prior to her degree obtained on 25/2/2014. Under such circumstances, this court is of the opinion that as NCTE have duly recognized that the degree obtained by the petitioner is a valid degree, it would meet the condition number 2 in terms with the letter dated, in terms with the communication dated 21/7/2016. However, as regards whether the petitioner had joined before 3/7/2012 is a matter to be verified at the level of the inspector of schools, that is the respondent number 3. Accordingly, the petitioner therefore is directed to submit a representation before the respondent number 3 along with the copy of the instant order, and the respondent number 3 shall verify as to whether the petitioner joined prior to 3/7/2012. On the basis of such verification so conducted, the respondent number 3, the respondent authorities shall grant the petitioner the advance increment within a period of 3 months from the date of submission of the representation. With the above, the petition stands disposed.
But in the impugn order may be vacated.
The impugn order dated 22/2020.
20 2020.
22/2020. Accordingly, it is further relevant to take note of that in view of the specific stand taken by the NCTE in its affidavit, the impugn order dated 22/2020 stands set aside, interfered with, and set aside and quashed.
Obliged.
Yes, Mr. Doctor, why are you waiting so long? Anything urgent?
I don't have any urgency.
You are the respondent, nothing. Okay. And any urgent matters? No urgent matters.
Item 43, Lordship, that is related to compassionate salary, Lordship. My Lord, not getting any salary, my Lord, the death of mother. A minor, my Lord, a baby, my Lord, 2 years baby. As per scheme, my Lord, full salary is given by the government until the date of retirement of my Lord, the government employee expired. So if it is not possible, that may be fixed, Lordship.
Yeah, get it ready. And you?
I am appearing on behalf of the respondent number 7 in this case, my Lord. We would like to file an affidavit, my Lord. So 2 weeks time, my Lord.
That may be fixed.
We'll have it on your matter. We'll have it on 21st June. Mr. M.H. Ahmed appears on behalf of the petitioner. Mr.
As does, my Lord.
Huh?
As does.
As does appears for the respondent number 7 and requests for an accommodation to file an affidavit. List the matter on 21st of June 2023. In the meantime, the respondent number 7 shall file the affidavit by 19th of June without pay.
Lordship,
in respect of item number 44, Lordship, is a suspension matter, Lordship.
Then why didn't you mention it already? Yes, Mr. Doctor, you are bullying.
I'll file a affidavit in this case, my.
Suspension for what?
For
Under what provision?
Service misconduct, my.
Suspension under what provision?
Lordship, I am the doctor. Certain allegation against me on the basis of a publication of some Facebook page, Lordship. And Lordship, that I have not complied with the order of my senior. I am presently serving. I am as a psychiatrist in the Tezpur Hospital, Lordship, in the mental.
This subsequent issue, my.
And Lordship,
Earlier, my lord, submitted application for leave, my lord, and in spite of circular to attend
Independence
15
Day,
August,
Lordship.
he left the premises and
No. Are we in the state of suspension till now?
Yes, my
No
lord.
departmental proceedings.
No proceeding, my lord, but he has not cooperated.
No, Lordship.
So what have you done?
We have issued repeated.
Understood. Then there is
Then,
no provision of a
we are
going
trying
ex
to-
parte.
We are trying to complete it or complete it, my.
Then why are you not doing it?
In this case, my lord, I will pay a
Unnecessary taking time for filing affidavit,
affidavit,
wasting
my lord.
papers. You do it by e-filing.
I am preparing the affidavit, my lord.
And
Because it is pending for, they have filed an additional affidavit, my.
okay, we'll have it on 16th of June.
16 of Lordship.
List the matter on 16th of June.
Much obliged.
In the meantime, the US central government,
Yes, for all the respondents, my lord.
is that the central government?
General government.
You are a CGC, na?
CGC.
Mr. A.K. Datta, or to Mr. H. Bezburwa, the learned counsel appearing on behalf of the petitioner. Mr. A.K. Datta appears on behalf of the respondents and submits that he submits and requests for an accommodation for a week or so for the purpose of filing the affidavit. This is the matter on 16th of June 2023. The affidavit be filed by 14th of June 2023.
Lovely. Item number 41, pensionary benefit.
All are pensionary benefits, 1 or 2 pension not happening.
He said, he said that, my lord.